Lord, may I be permitted to mention a matter for inclusion under the heading application, my Lord?
Application, what is the application for?
My Lord,
Yes.
My lord, for correction, my lord.
Action.
Another is, my lord, for inclusion in the list. Inclusion.
Under what heading?
My lord, group 1 matter. Group 1 matter.
Hearing or motion?
Motion, new motion.
Lord, that application is for what I am not aware of.
Please go through the brief then mention. Yes.
My lord, mention to listed motion, my lord.
Lordship, may I be permitted to mention one matter for upgradation? Lordship,
Please indicate the urgency, hand over the.
Lordship, petitioner's land was acquired by the
Please indicate the urgency in the list.
My lord, my lord, we are permitted to mention. My lord, this is a civil division where lordship has heard in part, man. For another hearing heading, my lord. Your lordship.
What in part?
Yes,
Hand over.
may I permit to mention your lordship two land matters, group 1 under motion state.
Motion, hand over the.
But I'm Mr. Matter, my lord. 510 of the monthly is, my lord. Exchange of video, my lord. Exchange of water. They have to.
Extension of which when it is expiring.
They have to tomorrow 15.
Please indicate when it is expiring, hand over the slip.
Which,
Yes.
Your Lordship, for inclusion under the heading motion.
Your Lordship, the Lordships kindly.
Motions, please hand over the slip.
Your Lordship, I'd be requesting for mentioning a matter for inclusion of an application. So
What is
my
the application for?
so the application is for restoration.
Hand over the slip.
Lordship, may I permitted to mention. Lordship, this matter was fixed for orders under the heading for orders on April 23rd, 2025.
For orders.
Yes, Lordship.
Hand over the slip.
My lord, for inclusion in the list for restoration application, my lord. My lord, may be permitted to mention another matter, my lord.
Operator, please indicate the urgency and hand over the slip.
My lord, may be permitted to mention another matter, my lord. My lord, for substitution application.
Substitution within time.
My lord.
Within time, it has to be before the registrar logima. Yes.
My Lord, may I be permitted to mention a restoration application in connection with the contempt application. This was dismissed in 2023, my lord. Restoration has been preferred. It may kindly be included, my lord, in the list.
A new motion, my Lord.
Contempt, my order.
My lord Justice Jyotirmoy Bhattacharya.
Pre
Yes,
2010.
yes.
New motion, my Lord.
My lord, one more mentioning, my lord. This is a hearing matter, my lord. However,
New motion.
affidavits are yet to be exchanged. The direction for affidavit was passed in the month of May 2025, my lord. We have since mentioned the matter twice. However, due to difficulties in searching for the file, the matter could not be listed. My lord, may it kindly be listed, my lord. We'll inquire in the department so that the file may reach the court, my lord. This
To be mentioned.
this petitioner is suffering, my lord. Is dismissed employee.
To be mentioned.
It's a cooperative group 5 matter. I shall, yes, দিয়ে দিচ্ছি।
My lord, 2016 hearing matter. In spite of repeated occasion, the state did not file their opposition, my lord.
To be mentioned. Yes. On the list. Number 1.
My Lord, I have got the petition.
Yes.
My Lord, I am aggrieved by the order of the my Lord, by the order of the DM, who is the appellate authority, whereby my Lord, the DM has upheld the order of the SDO, directing my Lord eviction me from the land in question, my Lord, on the allegation that I erected an unauthorized construction there, my Lord.
Where is that order?
Yes, my Lord. My Lord, the very first page 54 is the order passed by the DA.
Public land eviction of unauthorized
Yes.
occupants act, I do not have determination.
My Lord, that is the main issue because it is in pursuant to a order passed by this honorable court in the earlier round of litigation.
But public land eviction of unauthorized occupant act, I do not have determination.
My Lord, may I submit, my Lord, subject to correction, my Lord. This particular proceeding that my Lord, was drawn up under this particular act. That is the main challenge because it is completely without jurisdiction.
Yes, but I cannot take up the, please move the bench which has the determination with regard to that. For want of determination, let
9 of the
That's the problem, Mr. Mahato. Now the acts have been.
Which has been maintained, my lord, actually, that is not the proper act. The proper act is the, my lord, the
West Bengal Highway Act. The
Highway
proceeding has to be initiated, and this is in pursuant my lord, earlier order passed by this honorable page 39. Kindly consider once, my lord. The court had directed that the proceeding should be initiated under that particular West Bengal Highway Act. Page 39, my lord, the earlier round of litigation, the order passed in the
High Court directed under the Highways Act.
Yes,
yes, yes.
and they had initiated this, and repeatedly, my lord, I have agitated this point. Page 39 is the my lord, order starts from page 39. And paragraph 10 of the order, page 41.
I appreciate that, but Mr. Mahato, this is the problem.
My lord can take.
My lord, the authority should proceed with in terms of the order of the, my lord, the coordinate earlier order. Because of, my lord, this is the PWD led. Petitioner has a very bad petitioner.
I'm keeping it for tomorrow. Let me.
Sleep down.
So the
My lord, in item number 2, my lord, the office of the GP has not yet been served. All the other parties have been served. They leave to.
other parties have been served.
My lord.
Private parties have been served.
My lord, my lord.
Yes, what is this matter?
My lord, in a mutation proceeding, my lord, the name of the petitioners were removed and the name of the private respondent was recorded.
Mutation under section
50 of the Land Reforms Act. Now,
tribunal is the remedy.
tribunal is there, but without giving any opportunity of hearing and also without
That
conducting
point
any.
also can be taken before the tribunal.
But your lordship, my lord, can my lord pass an order where, my lord, there is violation of natural justice, my lord. Kindly consider, my lord,
Violation of natural justice, it's all right, but when there is a forum and the civil high court's jurisdiction has been curtailed under the statute.
But, my lord, without giving any opportunity of hearing,
Yes,
kindly
Mr.
consider.
Day, can you appear in this? Please give a copy to Mr. Day. The where is the order? Which order you are challenging?
Let the order is at page number 42, 43, my lord.
43.
But kindly consider, my lord, without giving any opportunity of hearing, the order has been passed. Kindly consider, my lord.
The
My lord, only one prayer, my lord. In the item number, I have filed the affidavit of sir.
This service taken on. একটা জিনিস ওইখানে yes.
No, item number 3, I am for the petition in this matter.
Yes.
Lord, may I pray for not today?
Why?
Just now I have received the bill.
Let me see what is there.
Well, I am challenging an order passed by the Executive Engineer National Highway Authority. That is at page 184 of the
Page?
84.
Yes.
My lord, this order was passed in terms of the order of the division bench passed by this honorable court. My lord, order dated on 25th of November 2025. And this is a cryptic order. My lord, kindly come to the order. The reason order is being passed in accordance with the control of National Highway within bracket National and Traffic 2002 in compliance of the solemn order of the Honorable High Court dated such and such WPN number 11783 connected to the WPN number 783 of the 2022. According to the land demarcation report submitted by the BLO Namkhana, the 4 persons are identified responsible for unauthorized construction: Abdul Soman Ali Khan, Amarul Sheikh, Susuma Pal. In compliance of the aforesaid order of the Honorable Court, Abdul Soman Ali Khan and Tapan Das appeared, undersigned, and the representation of both parties is duly been considered. But the land demarcation report has been found to be correct upon physical inspection. Based on this finding of the BLR, the undersigned have directed to Abu Supan Khan, son of Nabi Ali Khan, and Susama Pal to remove the unauthorized encroachment and occupation within 15 days from the date of this order, passing of the order. I am challenging this order. This order was passed in terms of the order of the division bench. What is happened? This Tapan Das is earlier moved a writ petition alleging the unauthorized construction by some other person. The representation of the Tapan Pal that is directed to be considered. You will also kindly come to page 59 of the order of the division bench.
Page
59.
Yes.
Where the proceeding was initiated under the West Bengal Highway Act. This on page 59 was the order dated 14th of March 2024.
Yes.
The relevant portion, may I just page 65.
This appeal was preferred by you.
Page 65, kindly come to page 65. The order of the SDO of 10-3 proceeding was set aside. The direction, however, second bracket, however, if understood has been made by the applicant on remove due process of law observed in principle of national justice. Tapan has made representation dated 2nd of March 2022 addressed to the various officers in the administrative, including the Executive Engineer National Highway Authority, who we are told is the Highway Administration. We direct the Highway Administration to consider the representation made by the Tapan and dispose of the same by following due process of law within a period of 6 weeks from the date of communication of this order, along with the representation by the Tapan to the Highway Administration. A reason order will be passed in Highway Administration after affording opportunity of hearing to all concerned parties, including Tapan and applicant therein. Needless to say, if the Highway Officer find encroachment national highway land, shall be take steps to removal of such encroachment in accordance with law. Not kindly come to the Tapan representation that is at page 55.
Yes.
My lord, you will also kindly see that top, my lord, the representation dated 2nd of March 2023. 22. My lord, the representation, my lord, page 56, my lord, kindly come to page 56.
Yes.
Last paragraph, that in front, last paragraph, the in front of said land in between NH 117 on the said vacant premises, which is a public premises, some person, namely Gulshan Khan, son of late Ismail Khan, Anarul Sheikh, son of Rabbani Sheikh, both village of Rajnagar, Sinath, Gram Panchayat, post office Rajnagar, police station Kagdip, district South Chibis Pargana, and their family member forcibly and illegally occupied some portion of my unauthorized construction over the public premises. As a which
So no allegation against you.
No allegation against me. And my lord, kindly come to page 57 also.
Yes.
The pair is, my lord, kindly requesting or necessary steps to remove the unauthorized illegal construction of public premises.
So that authorizes you to encroach upon the
No, my lord, that is a two ground, my lord.
The first, the division is directed to consider the representation. There is no allegation. And second, my lord, the proceeding was.
Have you encroached or you have not encroached?
No, this is over the Rayati property of the public, the petitioner. This is not the national highway property.
Show me which is the Rayati property.
My lord, my lord, this is my lord. What is happening? The block land.
The record of rights of the Rayati property.
My lord,
Which
the
plot
record.
you are in occupation, show me that. Were you present at the time of demarcation?
No. Well, that is my specific and no demarcation, no notice was served upon me. The block land and landing professor conducted the demarcation. Kindly come to the page 80.
The report of demarcation.
That is not supplied to me even at the time of hearing before the authority. Page 83, it is my specific case before the authority. Kindly supply me copy of the inquiry report. Kindly come to the page, my lord. It is notes of argument I have filed, page 80 and 83, my lord, the cooperative 83. It is specifically mentioned that the inquiry report of the block land and animals on the basis of which the instance proceeding is going on was done without serving any notice to me. As appears from the notice itself, and behind my back, since my case is that I am not encroaching the property belongs to the national highway. At best, the same is the private property of Tapan Das, and as such, I am disputing the inquiry report of the block land and animals officer on the ground of
Which page you are placing?
Page 83, my lord.
83.
My last paragraph.
Yes, you are appearing for?
No, I am appearing for the top one. Initially, when application was moved, at that time, at the point of time, Gulshan Khan was there. But during pendency, Gulshan lived, handed over the possession to the landed clients. Now he is in possession. Proceeding has been initiated. He got an opportunity. And National Highway found that they have acquired not my land. Now he says this is my land. No, not my land.
The National Highway Authority.
Now, not only one, two, three, things I want to show. Lordship, kindly see.
State is the
State. Yes.
Lord, kindly see the previous litigations order. It start at page. Lord, it is start at page.
So was demarcation made in your presence?
No.
Yes, yes.
I'm asking him.
Yes. Now, kindly.
Was the writ petitioner present at the time of demarcation?
No, he was not present. He was not present.
Mr. Gali was
previously
was served because the demarcation, whether notice was
as of
no,
now, I'm totally
the Gulshan was there.
Just now I received the brief.
take instructions whether the
Everything, your lordship.
notice of demarcation was served and please produce the copy of the demarcation.
The Gulshan was there. Under whose possession was there?
Whatever.
Now, Lordship, kindly come, page only one paragraph I want to show, page 77. But order dated 28 October 2025, start from page 74.
Yes.
Paragraph not kindly come, paragraph 12.
12, yes.
Yes, in view of such, this court, while disposing of the instant writ petition, direct the respondent number 5 authority to dispose of the representation dated such and such as submitted by the private respondent number 12 herein in the light of the demarcation report of the jurisdictional BLLRO in terms of the provisional section 26(2) of the Act. Positively within a period of 6 minutes. Now, this is the report. This order he has in previous writ petition, he filed a writ petition. In his writ petition, this order has been passed. Now, when this order, this report, demarcation report, on the basis of that demarcation report, entire thing is going on. Now, state government has, yes, state government has submitted the report before this the honorable court in earlier litigation, earlier this writ petition. So once this the order is there, today he cannot say that the report of the BLRO is bad. He's accepted this order.
Not only that, kindly sees a note of argument, my lord, he has filed before the hearing officer. My lord, at
Where
page
is that?
80.
Page 80.
Page 80.
My lord, there is a note of argument which the petitioner placed.
Yes.
I, Abdul Sobhan Ali Khan, so and so state before years for. I and some other people are the landless person on the basis of the assurance that the government property will be allotted to us on the basis of patta. We are residing with our family members in temporary construction at Moja number so and so, which is far from so and our said possession in no way make any obstruction no encroachment over the national highway. In the month of so the notice was served upon him from the office of the SDO to explain regarding my encroachment over the national highway. Since it was found that I have made unauthorized occupation in front of Ela Dag number so, and accordingly I appeared in the office of SDO, stated all such fact regarding my prolonged possession of the said property. And before the acquire, I said, landed property over the national authority as well as prayed for some time to get from. So he himself is admitting that yes, I am encroaching but waiting for patta. At the time of hearing, I was intimate one Taponda so and so. Similar entire lordship will come. Then he prays for time, paid 81 penultimate para. At the time of hearing, I prayed for some time, and the same was allowed. But all on a sudden, we came to know that without giving any opportunity to produce a document, SDO passed the order.
That order of the SDO was satisfied
Once,
by the division bench.
So then comes MAT, then comes Mandama's appeal. Thereafter, hearing. Now kindly comes to Miller 83, page 83, Miller. Since the complaint dated 2nd March 2022 regarding removal of blockage of his ingress and egress in front of the residential house of plot number 276 by one Gulshan Khan Anarul Sheikh, as such initial process for removal unauthorized compliance in compliance of subsection 2 of section 20 the Control of National Highway Act against me does not sustain in law. This is Milord, utter Milord. So where does he say that I was not given the opportunity of hearing this, that he has
Page 83, paragraph, last
participated. He has participated.
Page 83, last paragraph.
Yes, it is specifically mentioned the inquiry report of the BLRO on the basis of which the instant proceeding is going on was done without serving any notice to me as it appears from the notice itself and behind my back. Since my case is that I am not encroaching the property belonging to National Highway. At best, the same is private property of Tapon Das, and as such, I am disputing the inquiry report BLS. So either I am an encroacher of Tapon, encroaching on the property of Tapon Das. It's an appealable order. There's an appealable order too.
26(1).
This is an appealable order.
This page 84.
Page 84 is an appealable order. Yes, Mr. Bhattacharya, how can you challenge the BLRO report now? Please kindly come to page 77.
Before that, page 76, paragraph number 10.
Please kindly come to page 77, paragraph 12.
Yes, my lord.
In your writ petition, the coordinate bench directed the representation to be considered in the light of that demarcation.
My lord, the BLR report I have paid
on
for.
your writ petition, that order has
My
not
lord,
been challenged. You cannot now challenge the.
No, I am not challenged, my lord. I am saying that the BLR report, whichever you produce at the time of hearing, kindly supply me a copy. So that, my lord, kindly come to the order once, my lord, the order 84, everything on based of the BLR report. My lord, I am not entitled to get a copy of the BLR report, which is relied on at the time of proceeding.
It was placed earlier litigation.
Nothing
before
was
this
given
honorable
to me,
court
my
and
lord.
court
Kindly
passed
see,
the
my lord.
order.
After going through the order dated
মিস থেকে না?
এটা করে দিন
I'm for the petition.
yes,
I'm for the statement.
yes.
What happens, my lord? As per the management concession rule 216, any order passed by the district magistrate, I can challenge on the basis of an appeal, rule 51. My lord, I preferred an appeal before the divisional commissioner Mednipur. My lord, what happens, my lord? They fixed a date.
No, appeal under what provision? Which provision?
And under rule 51 of the West Bengal minor mineral concession rules.
That appeal is pending.
What happens, my lord? The date was fixed. My lord, come to page 6, paragraph 10 and 11. I have stated everything.
Yes.
On the basis of the first day hearing, due to what from the court premises, I was on the online process. But due to Wi-Fi disturbance, the hearing was stopped. I prayed for the second time. Second date was fixed, but from that date on the 21st April 2025, due to from the court premises, I was on the online. Hearing was started, but due to link failure, it was stopped. Well, what is my fault? I pray for.
What has been done? Order has been passed.
No order. Nothing. Hearing
What do
is
you want? You want an
I am
opportunity of hearing.
I am praying for a fixing of a date of hearing.
No difficult. Only thing that I don't have instruction in the matter. Whether an order has been passed in the meantime or not, I don't know.
No order has been passed.
My lord, I'm just saying, but I don't have that instruction.
My lord?
So if order is not passed, Lord, a date may be fixed for hearing, and or I can come back after.
Tomorrow I am keeping it.
Kindly page my representative.
Only whether
whether order has been passed. Day after tomorrow.
Day after tomorrow I am keeping it. Please take instructions and if not, please specify a date.
Yes.
So that no further notice. It will be recorded that on
two
that
occasions
date.
Because of link failure, my lord, hearing could not be conducted. We shall try on that day. But again, if there's a link failure, there should be some alternative arrangement.
Take an alternative way because 2 times there was link failure.
Yes, definitely.
So
My learned senior friend will appear virtually. If there is any difficulty, then somebody should be present there too.
Somebody should be physically present there. Ask your client then.
Can you fix the date? Whatever it may be.
Mr. Tansi, please take instructions whether any order has been passed. If not, please fix a suitable date so that I will direct him to appear on that. The grievance of the petitioner is that the petitioner, though
My lord, Mr. Ashim Kumar Rath is appearing for the petitioner.
Yes.
He is on the way, my lord. I pray for a pass over. I pray for a pass over, my lord.
My lord, I'm for the respondent number 3, Metro Railway. My lord, here, my lord,
I have also sought for instruction, but before that, my lord, I would like to point out a few things, my lord. On the similar cause of action, a writ petition is pending, and there are several orders passed, my lord, including the direction to file an affidavit, my lord, a report in the form of an affidavit. Exception has been filed. That is also pending. The similar prayers have been
Yes,
made.
what is your prayer in the writ petition?
I don't have an instruction, my lord.
But
I
the advocate on record.
No, my lord.
Where is the advocate on record?
My lord, he's coming. My lord, I pray for a Passover, my lord. Ashim Kumar Raut is appearing for the petitioner.
Prayers are more of civil in nature, my lord, and apart from that, my lord, the answering respondent would be the, my lord, Railway Vikas Nigam Limited, where, my lord,
You are not representing.
I am Metro Railway, my lord.
Yes.
My lord, the body which, my lord, functions this, looks after this construction work is the Railway Vikas Nigam Limited. Page 68 is the, my lord, representation made. That is also addressed to, my lord, RVNL.
Ask him to come. Yes, call the next matter.
Yeah, to your lordship.
Yes.
For private respondents, sub.
Yeah.
I'm for the
State. Yes.
Lord, Lord, I have come against the inaction and laches on the part of the respondent authority in respect of, in spite of receiving repeated verbal and written representation for removal of the unauthorized construction encroachment upon the PW land, and encroaching the front side of the right land of the petitioner's dwelling house, and also constructed illegally
Land or road?
Road.
No, my lord, by PWD land, everywhere it is written.
No, PWD land, because that is by the side of the Egra to Solpata bus
Whether
route.
it forms within the PWD road or not.
PWD.
Road, then I
No.
It is PWD land is here.
That is by encroaching the PWD land, obstructing the front side of the petitioner, constructed the toilet and other construction is there.
Your representation.
That is at page number 25, my lord. And the last portion will kindly see. অতএব মহাশয় আমাদের বিনীত নিবেদন এই যে উক্ত তফসিল প্রণীত রায়ত বাস্তুভূমির সম্মুখভাগে অবৈধ শৌচালয় ও জোরপুর অবরোধ দখলিকার উচ্ছেদের ব্যবস্থা গ্রহণ করলে আমরা
constructed.
Construct the private respondents. Their names are left hand side bottom middle.
What is your instruction?
Well, instruction is required because BLLR is given.
Long back it is they have received. They have received in the month of August 2025, page number 28. Long back they have received.
You are the owner of which plot?
I'm the owner of plot number 124. 124. And I have purchased in the year 1948. And upon conversion, there is a dwelling house there. I'm the recorded riot.
Claims to be the owner of.
all have to
They
deliver.
got the land.
Naturally.
In item number 7, my lord, I beg to appear for the petitioner, my lord.
But I appear
In
for
this
respondent
matter,
number
I
12.
am led by Learned Senior Counsel Debojyoti Basu, my lord. He has
Please start, please start.
kindly, my lord, gives me a passover, my lord.
But this matter, this petition is not maintainable because whatever grievance they have lodged before your lordship, that grievance can only be addressed to by the West Bengal Land Reforms and Tenancy Tribunal.
What is the dispute?
The dispute is that may I just indicate to your lordship? Well,
Yes,
Yes, my lord.
want to start? All right.
Yes, my lord.
Yes.
If your lordship is not granting a passover, then I have to, my
Yes,
lord.
yes.
My lord, I'm a school, my lord, in Bodartola, which is South Chowbish Pargana, my lord. I'm a government sponsored school. I'm a all girls school, my lord. I'm funded by the government, my lord. My lord, I had a capacity of a particular amount of students, and that is why I only had the capacity to run till class 10. Class 10. Yes, my lord. So, my lord, the private respondents are coming in the picture. I'll tell my lord why. My lord, there's a huge chunk of land which used to belong to the jute mill, my lord. The National Jute Manufacturers Corporation Limited, very big land, my lord. My plot of land, my school, is very much adjacent to that school, to that piece of land, my lord. No, my lord, since 2016, my lord, I have been writing representations to the jute mill as well as the education department as well as various desks of the land department saying that, see, I want to upgrade myself to the class 12 and also I don't have a playground. I don't have a playground and I have to make a library. So for that purpose, kindly give me 1 acre of land which is adjacent to my land. And because the boundary is the big land and my boundary, the same boundary, my lord. So I want 1 acre of land from that.
Adjacent to your property.
Yes, adjacent to my property so that I can have a playground and also construct a library. My lord, this would have benefited me in the way that I could have gotten higher secondary sanctions and I could have done more development, my lord. My lord, 2 things, my lord. This is not a private run school, my lord. This is a government sponsored school. Even the salaries paid, the infrastructure, all are run by people of the locals and government sponsors, my lord. My lord, to that effect, I write several communications initially to the jute mill saying that.
What do you want?
Yes, my lord. What has happened in the meantime, my lord? My representations were considered. After considering those representations both by the education department and the land department, a reconnaissance survey was conducted to demarcate 1 acre of land in my favor, my lord. All those communications are annexed with this writ petition. I'll take, my lord. But in the sum and substance is this, my lord. Till 2019, all was good. I was on track. I was very sure that this particular piece of land would come to me because that was the representation from the government as well. There are documents, my lord, which I will show, which says that the education department is vouching for me before the land department. The several communications intersay the land department are showing that yes, go and do the survey, give me the status report, etc., etc. All was in positive favor, my lord. Sometime in 2019, my lord, this land huge piece of land, my lord, gets vested to the state, my lord. Now, my lord, after that.
Including the portion which was sought to be given to
Yes, yes, including the portion that was sought to be given to me, that 1 acre. I think it's more than 150, 170 acres, my lord, including that portion in that dark number itself, my lord. Or several dark numbers, when the dark number that I was pressing for was also a part of that, my lord. Hence my grievance, my lord. So that got vested. That got vested in February. In March, February of 2019, my lord. In March of 2019, there is another communication saying that in tandem with my previous positive averments. So a situation comes, my lord, that before the vesting, all documents are there. One document 1 month after the vesting is also in my favor. Then, my lord, at the time of reconnaissance survey, my lord, sometime in the month of October, the persons from the BLRO come and they are taking the measurement, my lord. The private respondent, the member, one of the persons in the at helm of the private respondent comes and obstructs it, says that I am the owner of the land. That is what they represent to us. And on that day, my lord, the reconnaissance survey was halted. I write again letters to the police saying that the people are coming and disturbing the reconnaissance survey. This is illegal. After a month or so, again a reconnaissance survey occurred, and that was completed, my lord. That the interim report was with me, my lord. The final report was not served with me. Be that as it may, my lord. Now, my lord, I learned from the locality that this land has been sanctioned. This, which was resumed by the government, this was given to the private respondent by virtue of a lease. The lease is of 2024. And there is a document that says of 2021 that says that the lease has been sanctioned in their favor, but the lease deed was not executed. The lease deed was only executed in 2024. In 2021, I get the document that they have been granted a sanction of the lease. In 2022, they have been granted a permission to appoint a developer and develop the property. My lord, the ambit, what I have also gone through the lease and everything, my lord. The purpose of the development is that there will be a commercial complex and all that will be done, my lord. PS Group is going to do that. Was that what I understand from the documents, my lord? Now, my lord, my simple grievance is this, my lord, that so many positive steps have been taken.
What do you want now? What is
I want is that 1 acre of land, my lord. I don't want 175 acres, nothing, my lord. I want the government to carve out that 1 acre of land, which is a very tiny part of the entire big land, which will not even affect them in any way, so that I can make a playground, so that I can extend the library. And I've taken sufficient pleadings to that effect, my lord. My school is run by the aid given by not only just the government, by doctors, advocates. And this is just not my averment or statement, my lord. This has been in the documents provided by the government. The education department is saying that, my lord. May I just take your lordship through those documents, my lord, from 1, 2, 3, 4, the communications, my lord. Kindly takes my first set of communications, which is addressed to the initially the jute mill, my lord. Your lordship will find it from page number 33 onwards.
Presentations are not required. Please show me the decision of the authorities, which says that they are contemplating giving 1 acre to you.
Yes, my lord. Very
Show
well.
me that.
Yes, yes, my lord. My lord will first take. My lord kindly takes page number 38 once, my lord. 37 onwards, my lord. Kindly takes 37, my lord. This is annexure P2, my lord. The lordship will see this is 36, 2017. 17, 18, 19, I'll just show the documents in consequence, my lord. 36, 2017, this is issued by the Assistant Secretary to the...
You wanted a long-term lease.
I wanted a long-term lease. I wanted a long-term lease.
In the meantime, according to you, long-term lease has been granted in favor of Mr. Majumdar's client.
Yes, my lord. Yes, my lord. Also, I'll show this, my lord. Kindly takes the most relevant document is page number 49, my lord.
49.
Page
yes.
number 49.
Yes, I have gone through 49.
Yes, my lord. This kindly sees the dates, my lord. 12/3/2019, my lord. This is the letter which has been issued, my lord. Kindly see it is forwarded to me as well at the bottom.
Yes.
Also, my lord, kindly reads this, my lord. Allows me to place this, my lord, sir, with reference to your memo number such and such dated 7/2/2019.
Yes, what is the next document you want?
Yes, my lord. My lord, page number 53, my lord.
Yes.
Page number 53 is the inspection book. This inspection happens on 21/10/2019. That is the first instance of a reconnaissance survey. And the second instance of reconnaissance survey happened on a month later, in November, my lord. Lordship will see, as per the order dated such and such, we inspected the land, plot number such and such, which is at page 53, my lord.
মেটেরিয়াল পয়েন্টটা তুলেছি ওদেরকে একটা শুনছি
Then, my lord, kindly takes page number 61 as well, my lord. This is a document, if your lordship is at 61, this is a document issued by...
Come to 62.
Yes, my lord. Yes, my lord. This is the 2024. At the very bottom paragraph, my lord.
Last paragraph of that.
Yes, my lord. I was just taking to your lordship on that.
Yes.
Your lordship will kindly take first, my lord, the prayers made in the petition.
Mr. Majumdar, please give me a minute. Yes, Mr. Dev, what is your stand?
My lord, that is, he filed an application before the authority will consider that aspect.
What application?
That is,
Representation.
Yes, my lord.
But
That is the after otherwise, my lord, we have nothing to say, my lord, as because my lord they filed an application before the authority. And authority will consider and give the any order. That is the final order. The nothing else is
Malad,
there.
kindly take the prayers for once.
Prayers.
Yes, Malad, first.
Yes.
And I am grateful to my learned friend for referring to the sanction made in 21, though that sanction order is not part of the records. Well, I am grateful. Can I take the prayer D for once? First, my lord, prayer A.
Yes.
Concern respond, particular respondent 15672, reserve, demarcate, and settle 1 acre area. Land in respect of out of Dag number so and so in favor of petitioner school for playground, educational expansion, etc. etc. Kindly take prayer D.
Yes.
Issue a writ of mandamus or appropriate direction commanding the concerned respondent authorities to forthwith conduct an independent, time-bound inquiry, administrative review into the entire process of sanction and execution of the purported long-term lease granted to respondent number 12 and to take consequential action in accordance with law. Now, Miller, kindly take for once my lord, page 55. This is their writing. Well, I am on maintainability only. I'll come to the merits later on. Kindly take, my lord, the second paragraph at page 55. I'm not troubling your lordship with the entirety of the.
Yes.
At present, through or though, I don't know, whatever, there's a strikeout or something. Though the referred land under section 6.3 of the West Bengal Estate Acquisition Act, Vaidi memo number so and so, dated 7 February 2019, a brick and cement wall, etc., along with JCB machine field is going on. Well, a right of retention was given on 7th of February 2019, admittedly.
7th of February
2019.
Yes.
That 7th of February 2019, they are aware of the memo, not challenging this writ petition. They cannot challenge in this writ petition. Now, Miller, kindly now take paragraph 18
of the
writ petition.
Page 13.
Because I am on maintainability.
Yes. Yes.
This is regarding the allegation that that they have no access from one side of the plot of the land. But what is most relevant is from paragraph 21 to 23. Well, they are challenging a sanction made by the government in exercise of the power conferred under section 4 capital B subsection 2 of the West Bengal Land Reforms Act. Read with Rule 6 as amended by the amendment rules of 2017. 21 to 23. My lord, kindly take 4B permits long-term leases for industrial and infrastructural purposes subject to public interest.
Prayer does not say so.
Prayer says so, my lord. Prayer says, prayer D. Inquire how the sanction has been made. And my lord, what is the consequence? Not only that, my lord, today, my lord, the entire land has been leased out. They want to carve out a particular area of land from the leasehold area, and then this lease has to go. This sanction has to go. This is a very well crafted writ petition, but it is not so. Kindly take from ground 3 to 7 of the grounds. We have to, lordship would obviously, this is the prayers have to be looked. It has to be read in the light of the grounds made in the writ petition. Our appellate side rule says so. The writ rule says so. Kindly take from ground 3, purported execution of 99-year lease over same land without notice or explanation frustrates the principal's legitimate expectation subject to judicial review. Then purported lease interdepartmental processes. Then again ground 5, purported impugn sanction and indenture are arbitrary and capricious inasmuch as they directly contradict the considered recommendation of the school education department. Then, my lord, ground 6, for that the purported lease is procedurally vitiated for non-compliance with fair and just administrative procedure. Then, my lord, ground 7, committed non-application of mind that educational news. Ground number 10, directly on section 4B2. For that section 4B2 of the WLR Act being an extraordinary power to alienate or lease public land must be exercised in transparent or coordinated and public interest driven manner. In the present case, the lack of coordination between the land department and the school education department renders the sanction legally questionable and procedurally untenable. Now, Miller, ground 23, which is at page 24 of the writ petition. Directly challenging the lease. Well, today what they could have challenged, they ought to have challenged the order of retention, which was made on February 7, 2019. That has not been done so before any forum. Well, the action of the Land and Land Reforms Department, that the power under section 4B2 has been exercised in an inappropriate manner, has to be made 4B2.
What does
That
4B2
4B2, my lordship will kindly take 4B2. This was inserted by the Amendment Act of 2017. My lordship would like to have the look at the note. Sure. This is how subsection 2. This is how subsection 2 was inserted. May I take your lordship to 4B2 for once?
Yes.
The book.
I've got the book.
Notwithstanding anything contained in this act or in any other law for the time being in force or in any agreement, custom or usage or in any decree, judgment, decision or award of any court, tribunal or authority where an intermediary has been allowed to retain. Subsection 2 এটা কি দিয়েছে তোকে?
No, that's the it has been inserted in 2017.
Right. No, তুই rules এর নোটিফিকেশনটা দিয়েছিস. Oh, I'm sorry. বইটা এটা I'm sorry, my lord. Well, I'm sorry.
Yes.
Kindly take, my lord, a classification with or without any order under clause G of subsection 1, read be subsection 3 of section 6 of the West Bengal Estate Acquisition Act 1953, hereinafter referred to as a retainer, or where such retainer has already transferred such land or any part thereof to any person or institution or company which is in possession of such land or part thereof by an instrument mentioned in subsection 1 of section 5 of this act, such retainer or transferee as the case may be, shall be deemed to hold such land or part thereof as lessee directly under the state government with effect from the date of vesting under the West Bengal Estate Acquisition Act or from the date of such transfer as the case may be, for any of the purposes as referred to in
Mr. Muruga, do you have the copy of the 2019 order?
2019 retention order? No, the 20 at present I do not have. But they are aware. But the retention, so my lord, the condition precedent for invoking the provisions contained in section 4B. এটা কি রিটেনশন অর্ডার? ঠিক আছে, ও বলে দিয়েছে অলরেডি 21 এর লিজ গ্রান্টিং স্যাংশন। The current book has to be there.
Yes. I've got the 2020.
In fact,
as current as you are.
Yes. Not that.
Not as current as you are having.
But my respectful submission before lordship is that the condition precedent for invoking the provision contained in section 4B(2) of the act, which has been inserted with effect from 2017, given date in 2017, my lord, is that it has to be the retainer or a transferee of the retainer.
So according to you, you have a right.
I have a right. Not only that, my lord, my right flows from my right of retention. 6.3. So unless until the right of retention is challenged or questioned in an appropriate forum, then obviously this writ petition is not maintainable. Even otherwise, my lord, they are conscious of the fact, my learned friend pointed out, appearing for the petitioner, that in 2021 sanction order was issued. In 2020, we kindly take their representation now, the last representation. The demand justice or whatever it may be. Kindly take, my lord, how they have worded their demand for justice. Well, I pointed out that 6.3 has been referred to at page 55.
In 2019.
2019.
Page representation.
Representation, it starts at page 64.
Yes. Initial few paragraphs are with.
And I am not troubling your lordship with the initial few paragraphs. Now, my lord, kindly take from paragraph 13.
13.
Yes. But this is all happening in 2021, 2019, 2021. To the utter shock and dismay, my client learned that the Land and Land Reforms and Refugee so-and-so department has already accorded a sanction in favor of Fab Leathers for a 99-year long-term lease for a large area of so-and-so acres, I think 17.105 acres, which includes the very dark 134 forming part of the land for which my client's request has been pending consideration for nearly 8 years. My client has learned that the lease was sanctioned under section 4B2 of the West Bengal Land and Land Reforms Act in favor of Fab Leather so-and-so. It has been further learned that subsequently an indenture of lease
So according
dated.
to you, he is challenging an action under section 4B2
Yes.
of a specified authority.
Yes, and he has to prefer declaration that the lease is invalid, which can be either done in my lord tribunal or in a suit court, not in writ court. Now, my lord, kindly take his prayers in the representation.
Yes.
Kindly take, my lord. 23, the representation. Paragraph 23 of the representation.
Paragraph 23.
Yes, my lord. Therefore, in view of the above, your good offices are requested to launch a comprehensive administrative review and inquiry be immediately conducted. I'm sorry, my lord, page 70. I'm so sorry, my lord, page 72. My lord has got that.
I've got
Well, I'm so sorry, my lord. I should have waited.
No. I was making some note. Yes.
Very well.
I've got that.
Therefore, in view of the above, your good offices are requested to launch a comprehensive administrative review and an inquiry be immediately conducted into the long-term lease. This is akin to prayer D made in the writ petition, executed in favor of Fab Leathers Limited under section 4B2 of the WBLR Act, particularly in respect of Dag number 134 so-and-so, in order to ascertain oversight and overlap with the school's proposal and propriety of such sanction. Well, this takes care of the fact that they are in fact challenging the sanction in an indirect manner, not directly, knowing fully well that if they have to challenge the,
According to you, it's such clever drafting.
it's clever drafting, well settled draft.
So, my lord, I anyhow, my lord, a compliment comes.
No, Mr. Basu is there, compliments are bound to come. So, my lord, whatever is there, now, my lord, kindly take now 24. It is imperative that pending such review, Messrs. Fab Leathers Limited and Messrs. So-and-so, PS Unicorn Garments so-and-so, and their are be prevented to carry out. But this is the injunction they are seeking. So they are in effect not challenging but challenging the retention order of 19, the sanction order of 21, and the lease of
Where is
24.
the sanction order of 21?
Not annexed, but pointed out by my learned friend during the course of hearing. My learned friend submitted that.
But they have referred about the.
They have not annexed.
They have not annexed.
60 order in page 55.
They have referred to the 60 order at page 55. During the course of submissions, my learned friend very rightly referred to the sanction order which was made in 21. Then, my lord, the lease. The sanction order. If your lordship wants that, my lord, 21 at the
2019 order also.
that not at present I do not have. Any. will this, if this writ petition is entertained, it would in effect, my lord, it would in effect, my lord, impinge upon, my lord, my right to carry on development work in a leasehold land which have been granted by the state. And I am the retainer. There is no doubt about it, or the transferee. So my respectful submission before your lordship is that since, my lord, WBLR Act is a specified act under the, my lord, West Bengal Land and Land Reforms Tenancy Tribunal Act 1997. My lord, if they have any grievance, my lord, in fact, my lord, I must tell your lordship the 2019 order, I put the question to myself with all humility, can it be challenged in 2026? 2026, my lord, which is 7 years later. I think কত বছর? 7 বছর, 7 years later. Lord, today, if you need, even if any leave is granted,
According to you, not directly but indirectly,
everything is being done. Yes, my lord. I've shown the grounds. But I've shown the grounds. Prayer also. And the prayer B is way more interesting. My lord, it is not restricted to that 1 acre. He wants a total injunction on any development work in and over the entire land. I tell your lordship the background. But I was not making this submission. There are at least 3 litigations, Taina. How many litigations? 3 litigation pending. A bus stand association says that this is a bus stand area. A PIL is pending. Then there is a police inaction pending, again by the bus stand association. Now this is this is the third attack by the school. And my lord, it is all, my lord, they have coincidentally all the litigants have engaged the same legal team.
that might be
That might be, my lord, knowledge of, my lord, whoever is acquainted.
yes. May not be acquainted upon whom the client
Can vest out trust. But my lord, my respectful submission is that this is a third attack. This is the third attack on this land. My lord, in fact, my lease deed, but I will produce my lease deed. Hache lease deed, the lease deed with me. My lease deed says that I am reserving 2 acre land, correct? Koto? School inside that premises. The lease deed contains that condition. That's a different school, which was an existing school.
There is an existing school there.
Kindly take, my lord, page 20, that sanction order. Sanction order I have handed up.
Mr. Majumdar, was it an
His granting memo to কোথায় বলা আছে? প্রথম পেজে, first page এ দেখি।
First page mein.
Which paragraph?
Yes, my lord. Kindly take first page.
And
First
a
paragraph.
school on 2 acres.
Yes. So, my lord, we are already accommodating an existing school.
Oh, existing school lying within the premises.
Yes, we are making that accommodation. The lease content, it's not an entirely a commercial project.
Mr. Majumdar, if you are doing so, can you not give?
I cannot. It is a fact.
After all, Mr. Majumdar, you have seen the path.
Yes.
Playground of another.
My lord, I tell you, lordship, my lord,
disputing.
I am not here to dispute anything. My submission before lordship is that today, as per the lease condition, I have to accommodate 1 school. Correct? Then, কত টাকা payment?
30 crore.
I mean, 30 crores already.
To the government, I paid.
To pay to the government, 30 crores. It's not, my lord, that I have taken this lease at a, my lord, throwaway price. 30
No,
crores.
not that. That's something if can be done. If you can.
My lord, then, my lord,
some portal
this
for the
is not.
playground.
I tell your lordship, it will like that. Your lordship remembers that Aesop's fable, camel and the tent. 1 camel will enter, followed by another camel, followed by another camel. Then I will be out of the tent one day.
Absolutely.
It's the camel and the tent theory. It's that old.
No, Mr. Majumdar, I'm not going into that. I'm asking you, can you take?
I've taken instruction. My lord,
after all, if it is a playground.
My lord, I tell you, lordship. My lord, this is not so innocuous as it looks. This is not so innocuous. My lord, they were aware of the sanction, I mean the retention order. What prevented them? from challenging the retention order before the appropriate forum?
But there are some letters.
Mala,
some
that's an
actions-
interdepartmental, that's an,
Yes,
Mala, I am not aware whatever interdepartmental
you are
correspond.
not aware, but it appears that there was some communication.
Your lordship will
from the
find
government.
once, my lord, the land reforms department was made aware of that application. Once the land reforms department, having regard to that application, still decides that the retainer has to get the land.
I'm not
Mala,
in the legal right to get.
Yes.
I'm only asking you if something can be
Mala,
done.
Mala,
for
I am
this.
not in a position to make that. Mala,
Can you take instructions
Mala,
on that?
Mala, I tell you, lordship, Mala, I had a Mala, early morning conference today. Mala, courtesy Mr. Chakraborty. But my lord, this is not we can do. Mala, we have done whatever we could do. Mala, because bus syndicate is knocking the door, this school is knocking the door. Mala, ultimately, I will be out of the land.
Breakfast হয়েছে তোমার সকালবেলা?
Friends, that's the new age. Well, I am not in a position. Well, your lordship knows me. Well, what I cannot do, I will not make that commitment before your lordship. I cannot make that commitment because it is not this. Well, after
What do you have to say on the maintenance?
well, one judgment I would like to cite. Well, even if well, on the ground that even if well, if the prayers and grounds everything is looked at, it is basically cancellation of deed of the lease deed. Well, the lease deed has to be cancelled. There is no doubt about it. Right, my lord.
If his prayer has to be accepted.
If the prayer has to be kindly take well, either it's a tribunal or it's the suit. Kindly take paragraph 54 of this judgment. I'm handing up copy here. One copy I will hand up. Page para 54. This is 2022. Sorry.
2022.
8 SCC 210.
Para 54.
Kindly take para 54.
Paragraph 54.
Yes.
দে কপিটা দে।
বললাম দেখে নাও।
দে না।
এখান থেকে দেখো।
At page 235 of the reports, my lord.
Para 54.
May I just read it out for your lordship?
Yes.
I'm sorry, my lord. In cases where a suit for title is filed with or without the relief of declaration that the registered document is null and void, what gets challenged is a combination of all the aforesaid three steps. Now, the three steps are spelled out at paragraph 53. Three steps that may be challenged in a suit for declaration either on the ground that the executant did not have a valid title to pass on, or on the ground that what was found in the document was not the signature of the executant, or on the ground that the signature of executant was obtained by fraud, coercion, etc. The second step of presentation of document and admitting the execution of the same may also be challenged on the very same grounds herein above. Such objections to the first and second of the aforesaid three steps are substantial and they strike at the very root of creation of the document. A challenge to the very execution of the document is a challenge to its very DNA, and any defect or illegality on the execution is congenital in nature. Therefore, such a challenge by its very nature has to be made only before the civil court and certainly not before the writ court.
Technicality, rite challenge kora jabe.
Anything.
Formalities have not been followed.
Yes.
Procedures have not been.
Namely, the act of registration is something that is registering authority is called upon to do statutorily, while the executant of the document and the person claiming under the document claimant are the only actors involved in the first two steps. The registering officer is the actor in the third step. Apart from the third step, which is wholly in the domain of the registering authority, he may also have a role to play in the second step when a document is presented for registration and the execution. the thereof is admitted, the role that is assigned to the registrar in the second step is that of the verification and identity of the person presenting the document for registration. But the second, third step can be challenged. Today, my lord, a lease deed has been executed. They do not challenge the authority of the executed. They do not challenge, my lord, the right of the retention order. They do not even challenge the sanction order. Finally, my lord, they make averments in the writ petition regarding, my lord, the execution of the lease deed in terms of section 4B2 of the West Bengal Land Reforms Act. Like, is that permissible? I put the question to myself with all humility.
Yes, Mr. Basu.
My lord, we challenge part say the decision-making process, my lord, in executing a document in favor of a private respondent. What Mr. Mojumdar, my landed senior friend, had says, my lord, what for we are here before your lordship. My junior friend has already addressed, my lord. In add to that, my lord, the state being a welfare state, the most supreme law, my lord, is to consider, my lord, welfare of the people. What we are. We run a girls' school. Well, may I just indicate, my lord?
Before going to that,
Lordship.
one thing, if you kindly come to your prayers,
Lordship.
the effective relief which you want is.
My lord, may I just
that to
start from
allocate-
prayer D itself? What Mr. Mojumdar has shown, my lord, prayer D itself.
Not D. So your best prayer is prayer C. Your effective best prayer is prayer C, right?
Ought to be, my lord.
So what is the relief you have claimed? So you want 1 acre of land to be allotted and settled in your favor.
For what
by,
purpose?
By way of
By way of settlement.
Under what provision of the statute? Provision of a statute.
My lord, according to me, well, I would come to that portion. My lord.
No, I'm asking you, settlement under what provision of statute?
6.3. 6.3. My lord, so
You
far.
want 6.3.
No. According to them, my lord, they.
According to you, you do not know what happened.
No.
You want some 1 acre of land
My lord. Correct.
settlement.
Correct. Here, my lord, I am absolutely, my lord, my lord.
That is why I told you prayer C is your best prayer.
Lordship.
So under what provision you want this settlement?
Now, my lord, may I just say this? May I address to lordship? My lord, what Mr. Mojumdar has says, my
Not
lord.
going to Mr. Mojumdar.
No, I am also not going. I am also not going, my lord.
Omit all the other prayers.
Yes. Now, my lord,
only prayer C. Under what provision of law you are entitled to settlement?
my lord, for the time being, my lord, let us consider, my lord, being a school, my lord, I only want, my lord, some portions of, my lord, land, my lord, to be included into my school for the purpose of promoting the school from secondary to higher secondary. Well, kindly bear me for a minute, my lord.
Sir,
My lord.
you want allotment of an 1 acre land.
My lord.
Under what provision this allotment is to be made? I'm asking.
But I do not know. I put it to the government. That is what, my lord, I am coming down. Here, my lord is sitting, my lord, in an extraordinary jurisdiction. What I would, my lord, start at the very onset, that here, my lord, my legitimate expectations are not even boiled down, but also being crystallized. And certain legal rights, my lord, and all, my lord, are, my lord, expectations, my lord, and promissory estoppel are being made.
Promissory estoppel and other things. Are you challenging this sanction order and the 6.3 order?
No, my lord, what I say, my lord, what I
I'm
say.
asking you, are you challenging those orders? Yes or no? If you say no, I will proceed in one way. If you say yes, I will proceed in
No, here, my lord, I do not challenge those orders. I say, my lord, the decision-making process by, my lord.
So if you don't challenge that order,
for
rightly or wrongly, something has been given in favor of Mr. Mojumdar's client by virtue of certain orders, then nothing can be done.
No, my lord, here, my lord.
Is yours. If you challenge, it's one thing. If you say you do not challenge, so some orders favoring them remains unchallenged. So you know, you are the best person, you know what is the effect of that. welfare state 226, powers are very wide, you know.
No, my lord, here, my lord, what I am on
That is why
today.
I'm asking you. If you want to challenge, it's one thing. If you say no, I do not want to challenge, it's a different thing. You can switch off the microphone and you can have conversation.
Yes, my lord, that is, your lordship will not concern in my lord, pronouncing any order, my lord. That I am, my lord,
Switch off
quite
and you can take instructions from.
And I will also
so
not
that
take
Mr.
any
Mishra
advantage.
also cannot.
I will not also take any advantage of
Now,
that.
my lord, here, my lord, even if, my lord, if I can say, my lord, even if we do not, my lord, pass say, my lord,
I'm asking you, please take a decision on that before proceeding, making further submission.
then my lord, kindly come back, my lord, so that I can, my lord, also take a decision. Because according to me, my lord, subject to, of course, my lord, kind
Whether you
consideration.
want to challenge those,
Yes,
yes or no?
only or to the extent, my lord, may I just take instructions, my lord? Because according to me, even if I do not challenge the order itself, my lord, I can very well challenge, my lord, the decision-making process in, my lord, passing the order. And that is what, my lord,
Go with that.
my lord, if I can take instructions, my lord, and come back. If I can take instructions, because if a lordship says, my lord, then I have to also decide and fix it. Because but otherwise, my lord, on papers, my lord, I can show, my lord, there has been a specific case of a promissory estoppel. There has been a specific case of a legitimate expectations. There has been a specific case, my lord, where the decision was already taken to give a long-term lease.
Can it be this promissory estoppel, legitimate expectation, even when third-party rights have accrued, can it be at the cost of such rights of the third parties? I'm asking you.
My lord, that is for the state to consider. That is for the state to
Mr.
consider.
Basu, whether that is why I am asking you, can it be all these principles, can it be at the cost of a third party in whose favor some rights,
Because I say,
rightly or wrongly, has been vested in favor of such third parties?
yes, rightly or wrongly, my
Can
lord,
be extended that far
my lord,
to take away the right
my
of the
lord,
third party?
my lord is absolutely, my lord, highlighting with me, rightly or wrongly. Now, my lord, here, my lord, I was the first person for whom, my lord, the state had initiated.
Mr. Basu, even if I accept that it was wrong,
My lord.
so that action has to be challenged. So simply some right, even if that is why I use the expression rightly or wrongly, even if wrongly, can this legitimate expectation and other things without going into those can be taken away? That right. Even without challenging, those orders can be nullified.
My lord, to my humble understanding, my lord, very well I could come, may I come back? I do not want to waste my lord's time, my lord, but I say, my lord, that could be. If your lordship, my lord, I shall try to satisfy your lordships, my lord, and if my lord, if holds, my lord, and
Then make your
kind
submissions
wisdom.
today. Then
My
I
lord,
can.
then, my lord, may I also
satisfy? Yes.
no, my lord,
Please, you
may
make
I
your
also take a instructions, my lord, because
Make your submissions.
this is not my decision whether, my lord, my client, my lord, wishes to challenge those part or not. Well, let me also clarify. Then, my lord, my submissions, my lord, I would be placing, my lord, for my lord's kind.
1 p.m.
1 p.m. Why? এত তাড়াতাড়ি তুমি যা তোমার
He
Huh?
has made me to hold a
তুমি তো
conference at 8:30
Huh?
a.m. So, I did not come.
No, yes, sir. For that, Mr. Bojumkar, for
That
that,
is, then, my lord,
if it's
then,
1
my
p.m.,
lord,
whether
if it is
tomorrow,
not today, I will
then
beseech your lordship.
no, not. I will be passing an order. I will be recording something.
Very well.
So Mr. Chakraborty cannot fly away.
Yes. No, Mr. Chakraborty, my lord, is a darling, in fact.
Yes.
Well, if your lordship will not be pleased enough, my lord, kindly see the last paragraph. Well, this is the final report, my lord. What was, my lord, ultimately, my lord, though, my lord, inspection was made, as my friend, my lord, submitted, that preliminary report was given.
When Mr. Basu have passed the order, I gave you a chance if you want to make submissions on merits today. You said
No, my lord,
come back.
my lord, in the
Have you
meantime, if
considered,
this report may be, my lord, made available. This was a report, my lord, the final report, which was prepared on 7/11/2019.
When do you want Thursday?
No, my lord, kindly keep it on Monday, my lord.
Friday.
My lord,
Matter, no. This
Well,
matter on
Thursday I have some.
then Monday. This
but the service be kept with the record.
My lord, item number 8 on behalf of the petitioner, my lord, this is my affidavit of service.
My lord, I am for the private respondents. My lord, I am paying, my lord, not today and tomorrow, because my lord, today itself, my lord, it has been handed over to me, my lord.
Yes, what is this matter?
My lord, matter is
the
related to, my lord, they are asking
My lord,
for
petitioner made an
demolition of
application.
unauthorized construction on which obstructed their ingress and egress.
Yes.
But I made an application before the authority concerned, page number 18, only to consider this matter, my lord.
My lord, I
Who
need
is for
to
the state?
I am appealing to you.
Yes, what is your instruction?
Instruction was not yet received, your lordship.
All right, I am directing them to consider this after
My lord,
hearing all the
only,
parties.
my lord, only one aspect, my lord, the allegations.
You are denying.
On the pre, my lord, the documents with us, my lord, showing that we are paying the, my lord, municipal taxes, and we are also paying, my lord, the we are also we have a connection with, but the at best, my lord, the trade certificate, sorry, my lord, the trade license is with us. So, my lord, three things, not on that, my lord. I am on that, my lord. Your lordship, my lord, kindly, my lord, consider the
This
issue
is not the
whether
ownership deed, my lord.
whether this, my lord, removal is applying in respect of, my lord, the right to fair compensation act or not. Whether we when the government.
No, if you have encroached upon a property.
No, my lord, that is the issues, my lord.
If you have not encroached.
My lord, that has to be, my lord, decided by your lordship, because there is a provision in the act itself, my lord, right to fair compensation. Even if my lord, I was there for 30 years, then
by encroaching upon the.
Yes, my lord,
show me that provision.
that's why, my lord, I am asking. My lord.
Under
That's why
the-
only 1 day or 2 days, my lord, 2 day after tomorrow.
Take all points there. I will direct.
Your lordship, kindly see, my lord, whether you that cannot be said, that cannot be decided by them whether this apply or not, my lord.
Why?
My lord, right to fair compensation, that whether it will apply to, my lord, this
Right to fair, sir. Right to fair compensation will apply in case of acquisition of your property.
Yes.
This is not acquisition of your property. If for acquisition, the previous act did not provide for resettlement, new act provides for resettlement and other things. No difficulty.
Yes,
But provided your property is being acquired, it does not apply in case if you have encroached upon the highway or the PWD road for removing that encroachment, fair compensation.
No, my lord, I need to, my lord, my lord, this is, my lord, for myself, my lord, I will show, my lord, there is a provision. My lord, the definitions clause
Come at
itself,
2 p.m.
my lord,
Come
that's
at
why,
2
my lord, that if it is
Come at
not.
2 p.m. Law point, come at 2 p.m. 2 p.m. Yes.
Tomorrow, at least, my lord, tomorrow, because I have.
With regard to
only
the provisions, you can come back.
My
at
lord,
2
my
p.m.
lord, but my lord, the other matters are there only. Well, only tomorrow.
Which time will be convenient? Please give me a time.
My lord.
Which time?
But after.
2 p.m. fixed আছে আজকে 10
My lord, 2 p.m. one matter has been fixed.
Give me a time.
3 p.m.
At 1 p.m.
3 p.m. your lordship.
3 p.m. All right, 3 p.m.
I will.
At 3 p.m.
I will try to, my lord.
Affidavit of service.
Please take it back. Yes. Yes, you take instructions from the state.
Yes, sir.
In the meantime, 3 p.m. Yes, call the next matter.
My lord, item number 9 on behalf of the petitioner. The petitioner made an application before the authority under the Act of Control of National Highway Land and Traffic Act for demolition of removal encroachment, my lord.
Yes, what happened?
My lord, thereafter the authority concerned is tried over this matter. My lord, page number 14 is my representation, my lord. Page number 14. 1-4.
Yes, and what is the order at page 23?
My lord, one public interest litigation was filed and ordered by the division bench, Chief Justice bench, my lord.
Yes.
The honorable bench given direction to the authority for demolition. This is the order of public interest litigation, my lord. Same self land in question, my lord.
No. Yes. What?
My lord, I am
for the private.
My lord, I am for the private respondent.
Yes.
My lord, so far the subject plot is concerned, my lord, the private respondent purchased the said plot and conversion has been made accordingly in terms of the, my lord, Land Reforms Act. My lord, so far the land mentioned in the writ petition, this is not the, my lord, subject land which has been passed by the, my lord, appeal bench. My lord, if your lordship kindly takes pen to the page 22.
All are the RS
My plots
plot
of
number,
my plots of land
this is the
is
RS
of,
plot
my lord,
number.
214 by 533.
Yes. All right, even if this is not part of the appeal bench, if there is an encroachment,
Well,
that
there
can
is no
be also.
my lord, there is no question of any encroachment, my lord.
Then consider that.
Well, let it be considered. There is no, my lord, kindly,
So I'm recording. You are in occupation of which plot?
my lord,
What is your plot number?
my lord, 214 by my lord, 533. This
214
land
by
was purchased.
533.
Yes, my lord, purchased 2022. Thereafter, my lord, conversion has been made by the
Purchased
SDO.
in 2002.
2.
And conversion made.
Conversion made. And this is not the land of my lord anyway connected with the my lord National Highway Authority.
Yes.
And in the representations, my lord, they have not made any schedule, my lord. Which land encroachment of the land in question, they have not mentioned the schedule. But cleverly, they have just filed an application, my lord.
Ashun, the petitioner
Lordship, item number 10, your lordships, I am appearing on behalf of laid by Mr. Mukherjee, your lordships, early occasion directions to the
On
filing
5th
report.
of December, your lordship directed
Lordship,
one
on
DM
that day I am
to
not
file a report.
appearing in this, I am serious illness. But lordship, kindly give me morning time. Next Monday, your lordship, I file this report. For only further.
Twice. How many times it will be extended?
Lordship, 5th, 2nd January, lordship, I am serious illness. Today I first appearing, your lordship.
5th of December was the initial,
Yes, yes.
then 5th of January it was
Lordship,
again
kindly
extended.
morning.
On the prayer of the learned advocate.
For 11, my lord, I'm appealing for the petition.
Not in this matter, my lord, as per your lordship direction, my lord, I have
কি বলছে?
in this report.
কি বলছে?
Oh, that technical.
Yes, my lord, that is a technical defect, my lord, we clarified that. We will
been
clarify
clarified?
that in 3 months. No, my lord, it will take time.
It will take time.
Some time.
Now you have given a copy of the record of rights. You have said that corrected.
After that, my lord, after correction, we have
How much time, Mr.
3 months, my lord, as because there is a provision of appeal, my lord, we must file appeal for correction of the same. And after that, my lord, we complete all the things, my lord, within 3 months.
So why you will prefer an appeal? There are some technical errors
For
in
that
the.
is, my lord, now, my lord, all the correction will be made by the, all the correction is made by the by ADM, my lord, district level, my lord.
Yes.
So, my lord, we have, he is always, my lord, in the, after that, we pass the order that will go to the ADM, and ADM will, in his laptop, my lord, that is, he will take that
Yes,
thing, my
Mr.
lord.
Chatterjee.
Within 3 months, my lord,
Lord, only one thing, my lord, let them take their time to correct. But only one thing, my application for mutation, which was I could not present it online because of the technical error, allow me to submit it physically so that they can accept it.
That can be done.
Yes, my lord. We can receive that. We file karo, I'm going.
Where is the, have you annexed that copy, Mr. Chatterjee?
Application, my lord, since online, my lord, we could not upload. We made our representation to that effect.
Where is that?
But that is at page 111, my lord.
So you want your application for mutation?
Yes.
You wanted to submit your application for mutation in respect of plot numbers. You have made.
Yes, my lord, I have mentioned it 537.
Only 537.
Only 537. Because there is a subsequent transfer, my lord, who is the third petitioner. My lord, he wanted to, my lord, incorporate his, he applied on.
Which paragraph you have stated?
Yes. That is paragraph number.
537 কি এর
শুধু
মধ্যে ছিল
হ্যাঁ হ্যাঁ
কোর্টের অর্ডারে
হ্যাঁ 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 that is paragraph 7.
Number 1.
Petition
sold to petitioner number 3.
3. That is
So
paragraph number
3 now wants to mutate his name.
Mutate his name, and by that time, my lord, the rest of the lands we find that, my lord, there is double recording, my lord, instead of that.
Where is so you have filed an application for correction also?
No, not correction. We say that, my lord, we could not approach online also because there is technical
So for
error.
correction also you could not approach.
Could not approach.
So there are two things. One, you have to one is application for mutation in respect of plot number 537.
537.
The others is with regard to correction of the record
Because there
of
is a technical error going on. Because online we find
which plots?
My lord, this is my paragraph 7 kindly turns into, my lord.
7.
Yes.
7 plot numbers. Oh,
My lord.
528.
537, 569, 570, 576.
537 also.
Yes, 537 is the subsequent transfer plot.
So 529 also.
Yes, apart from 529. 529 there is correct. My lord, there is correct.
Oh, it's correct.
Correct.
So only 528.
Two
five plots.
Yes. Supplementary correction.
And mutation. So, Mr. this application for correction can be submitted physically.
Yes, my lord, he can. Your lordship can pass the order, my lord, to that effect. As because there is discrepancy for that decision, my lord.
Yes.
And the
before which authority?
Before the BLRO.
3.
Yes,
Domjur.
Yes, my lord. BLRO. Domjur.
The petitioner Call the next matter. Yes.
Well, this is my matter, my lord. This is my lord. I have to submit a fresh application, 2022 reach application, 2023 reach application. My lord, to come back with the fresh service upon the respondents.
Why fresh application? What
Well,
is this
fresh
matter?
matter relating to the land compensation of the
Yes.
Act 2 1948.
Yes.
My lord, the 7A proceeding has been initiated. Thereafter, no compensation has been paid. My lord, page 33 is the complaint. My lord, I have to page 33.
It was acquired under the Act 2 of 48.
The Act 2 of 48. Page 27 is the notification.
Have you served upon the state?
Yes, this is my lord. I have been directed to serve the phrase, my copy of this upon the state.
Please give a copy to Mr. De. The learned
39 for the petitioner lordship, the petitioner and the private respondent number 12 to 14 are the co-owner of the land lordship who relinquished their some of the share to the PWD lordship. But unfortunately, PWD did not record their name in by taking that advantage lordship. The private respondent are doing illegal construction over there. I made complaint on 24th of February 2024.
Have you served upon the private respondents?
Lordship, sir, but not after mention, Lordship.
This upgradation. Yes, Mr. Dor, what is your instruction?
I have not received the instruction.
Why? It's a matter of 2024 July and you have not received instructions. Why?
Even I cannot catch hold of my junior, learned junior.
Where is your
Kindly, come to page 26.
Yes.
Can you direct the authority to consider upon giving all the necessary parties a hearing? Because in the writ petition, he says that he has relinquished in favor of PWD and subsequently, since the no recording had taken place in favor of PWD, the private respondents purchased the property and they are constructing on that land.
Lordship, in page number 23, Lordship, the reply.
Consider this.
Kindly direct the district magistrate. One, because district magistrate would have necessary informations regarding the acquisition, regarding the relinquishment.
I think, Mr. Dhar, you file a report that would be better.
Manan, I'll do that. ওটা কি বাবা? Bengal Highways Act? না, ওটা লাগবে না।
The petitioner has
Yes, my lord, 14, I beg to appear for the petitioner. My affidavit of service, everybody has been served. But the very short issue, my lord, the private respondents encroaching upon the state highway, they are, my lord, engaged in commercial activities. But if the representation is considered, my lord, by giving opportunity to all the parties, my lord, that would suffice, my lord.
Yes, Mr. Dev, what is the
Yes, my lord. Consider that representation, my lord. By the respondent engineer. 4. Respondent number 4, the subdivisional officer. 6. Subdivision officer. By the respondent number 2, my lord, assistant engineer.
Assistant engineer, public works plus.
Yes, my lord. Assistant engineer. ঠিক আছে, sir, ঠিক আছে।
You are the owner of which plot?
My lord, I am the owner of the plot. My plot is, my lord, yes, my lord, my plot is, it is mentioned in plate
Paragraph
number
3.
3,
Paragraph 3, my lord.
1.5 শতক মৌজা উত্তমপুর, jail number 88.
LR plot number 1212.
Yes, my lord.
Yes, my lord. One
Which
to one,
was RS plot number 991.
my
Yes,
lord,
my lord.
my lord.
The petitioner claims to be the owner Yes, Mr. Shanal.
For the petitioner lordship, this is my availability service. Renewal of lease lordship. Initially, lease was granted long-term lease for the lordship, encouraging small business in the state lordship. The lease was granted. That was subsequently renewed lordship. Thereafter, it expired lordship 2018. Prior to expiry lordship, I made representation, and if you lordship kindly consider page 41.
File a suit for specific performance.
Now, it's a lordship special circumstances this lease was granted. Now, they have lordship asked for the lordship from the BLRO.
Suit is not maintainable.
Now,
you are taking advantage of a renewal clause in the lease. No, there is no renewal clause.
Renewal clause is there, but
So file a suit for specific performance of contract, invoking that.
Now, according to
renewal
lordship,
clause.
earlier renewal, they are lordship acting in terms of lordship 219 of the land defense manual. So lordship 30 years renewal is earlier there. So I am lordship entitled to get another renewal if the condition is not.
That is why I'm telling you that.
But the authority lordship, in spite of lordship asking for the assessment from the BLRO, till date lordship
Who is appearing for the respondent?
It's only state is there lordship. I've served upon the lordship. Page 41, after lordship my expiry, prior to expiry, I made a representation, page 40, for renewal and for assessing the rental charges lordship. The authority asked from the BLRO lordship to submit a report.
Mr. Shanal, you have mentioned it for upgradation.
For new motion lordship, inclusion in the motion.
Inclusion in the motion, but
may I serve
upon the private respondent?
There is no private respondent, only state. If you lordship direct, I can lordship intimate the lordship learned advocate appearing
Who
for
is
the state.
appearing in this matter?
Then I have to take instruction from the GP office lordship.
You should have taken instructions first, then mentioned.
It's new motion lordship, so for inclusion it was. I will lordship intimate him lordship.
Filed in June. Mr. Shanal.
I am for the petitioner, my lord. 16 and 17, same matter, my lord.
Yes.
Unauthorized construction made by the private respondents on the PWD road in the front of the petitioner's land.
Yes.
Petitioner made a representation before the authority concerns, but not considered till today.
Have you served upon the private?
Yes, my lord.
Mr. Banerjee is for the state in this matter. Mr. On Banerjee.
Yes.
He has left the court, Lordship, due to his personal difficulty. So, Lordship, kindly make it not today.
Who is his junior? You are his junior.
Yes, Lordship.
All right. The is same.
Yes, mostly. I am for the PT.
Yes.
Lord, Mr. Banerjee has left the court due to his personal difficulty, my lord.
Who is assisting him?
Lord, Lord, I am
Please ask from him. Ask him to appear.
next matter I got an opportunity to appear for the state.
Who has given you opportunity?
Have been
Yes. Yes.
already intimated the block land informs officer for demarcation.
But for demarcation, when? September? No.
September 2025.
No. July 2025.
So after that, my lord, the second reminder has been given.
Yes.
It
In
will be-
September.
It will be done.
Now we are in January. How long a demarcation takes, Mr. Mukherjee? We don't know how long he will take. From January, how much time it will be taken?
It should not be, my lord.
I'm asking you, how much time it should be taken from now?
Your lordship will, the last order which your lordship has been passed, kindly pass the similar order, my lord.
No, not similar order. It will be a different type of order. Please give me the timeline within which the BLRO will demarcate that.
But,
Because 2 times he has failed. So now you suggest a time limit, I will put that time limit here.
kindly give a direction.
How much time I'm asking you demarcation?
Fortnight?
Fortnight. Ashur.
Court's order.
Why, Mr. Mukherjee? You don't have any control. You are looking from July, the authority. So, can you not make a submission before the court that it will be done within such and such time?
Problem is I'm telling you, lordship. But I had a talk with the lord, this personal testimony of PWD. He is saying that 2 times reminder has been given. If the report is not come, what we shall do? Kindly give a direction, mandated direction. So within fortnight, the demarcation be done and proceeding can be completed within certain time. 17 we will not be here.
Who will not be here?
We will not be here because order will be server, my lord. We will have to communicate. Kindly give some time, my lord.
15 to 17, we will not be here. Who will not be here?
I will not be here, my lord.
Today we are on
13.
13th.
Because order will be
Please
server.
remind me if it is not served by tomorrow. And Mr. Mukherjee, this order has been passed in open court. Without that server, you can also make this communication. Make that communication. Let
If we communicate to the BLRO that you must do this within this time, my lord, he will do that. BLRO তো phone করো।
করে দে।
হ্যাঁ, করবো।
করে দে।
না করলে আমাকে বলো, আমি বলবো।
tell him over telephone, this is the order passed. In case he does not act, please report it. Then let's say.
Lordship, item number 5, Lordship, passover matter, that item number 5 pertains to Metro Railway. Petitioner is here, Lordship.
Yes, please wait. Yes. Yes, call the next matter.
Well, this is my petition.
Yes.
Very briefly, there is a lease. Government
How
lease.
much time it will take?
10, 15, 10 minutes.
2 p.m. Who is for the other side?
I'm for the private respondent number 3.
And who
There's
is for the
no
authority?
conflict with them. Oh, we
Who is
have
the real contesting party.
the two state respondent numbers 1 and 2. I don't think that there's real consent. This is
Who is appearing.
I don't know. Tomorrow we had served on mentioning time also. We gave notice
So ask your advocate on record
to bring someone.
who has been, not to bring someone who has been engaged. Where is this matter? Mr. Dey, what is happening? No matter the state advocates are
Can we request Mr. Dey to? Can I serve him now, Mr. Dey? It will be very good, my
So
lord.
this is the only because I'm requesting Mr. Dey.
Kindly request him. I'm
Please
giving.
ask your advocate on record who has been engaged. Ask him to intimate to come at 2 p.m. If not, then I will bring. Because if someone has been engaged in all matters, yes, call the passover matter. Yes.
I beg to appear for the petition.
Yes, who is for the private? You are for the
The
state.
Metro Railway, Lordship.
Oh, Metro Rail.
None was appearing for the state.
Private party, no. Yes, what is this?
Lordship. Similar
The action of the Metro Railway has been challenged here. Lord, from changing the proposed railway station,
Or
changing the Lord, proposed railway station from the Lord, place to the different place, which was earlier fixed, which is causing Lord, disturbance the running of the business of the prisoners. Lord, may I just indicate.
Lordship, I need to instruction.
Lord,
RVNL.
MD, আমাকে বলতে দাও। One MD Trade Link Private Limited purchased a land of 15 decimals. Milord, after purchasing that, Milord, he has, Milord, by an agreement, Milord, given that land for the purpose of running the business by the prisoners before your lordship. Milord, he has started his tires business, wholesale and retail tire business. Milord, your lordship knows, Milord, there is a Rajarhat New Town project, Milord, which was undertaken by the state government by acquiring several Milord lands in questions. Milord, portions of the lands have been acquisition for the purpose of Milord New Town Raja. After that, Milord, the Metro Railway from Salt Lake to airport, your lordship will know that from Salt Lake to airport, Milord, that expansion was done by the Metro Railway authorities. But that Metro Rail authorities have taken the land from the state government, Milord, which is commonly known as, Milord, that Bisho Bangla Saroni. Over that road, Milord, the Metro Rail started the construction. Lord, I am running the business in the middle of the portion and 900 meters from Titumir station and from 600 meters from Milord, the Chinar Park station. In the middle portion, I am there. Lord, I am Lord, running the business on my Milord Rayoti land. In front of my Rayoti land, there is a land occupied by the West Bengal Infrastructure Development Corporation Limited. Now that road is Lord commonly used for the purpose of footpath and some portions are vacant. Your lordship knows, Milord, all these things. Now, Milord, what has happened here? initially, the Chinar Park station was proposed in terms of their the proposal, that Chinar Park station was far away from the front portion of the petitioners. Recently, that was changed and came to the front portion of that, of the business of the petitioners. And it now started the construction. We have no problem if the entire the ingress and egress of the metro through the escalator or something like that, or inside the staircase within the zone of the land, we have no difficulties. But question is that they have started construction from ingress and egress to the metro station.
This is a technical aspect. How can the court?
No, the question now here, the
which place?
no, the questions of here, questions of two more fundamental questions are here. One is that the original the place which was earmarked for the Chinar Park station, that was changed, that cannot be changed in my humble respectful submission before Lordship. Number one.
Why?
Because
some defect or
no, there is no defect at all. Only to there is no defect. Only to favor some hotelier businessman. They have shifted that because initially which was done. That was in front of a hotel, 5-star hotel. Subsequently it was changed not from that and in front of me. But my livelihood goes. If it is
now, Mr. Raut, if it is changed from that to another place, someone will come.
No. I have annexed.
Development, nothing.
No. I am not against the development. I am submitting before Lordship with great respect, I am not against the development. Question is there are several lands, and sides of the lands are open for that purpose. This is not that case. This is not the Calcutta. This is Chinar Park, not 24 Prognas. There are several roadsides areas are open. And in the similar circumstances, a petition was filed before this honorable court. Kindly see the order passed by this honorable court. At page 87, annexure P6.
Yes.
May I read?
Yes.
The contention of the petitioner is that the petitioner and other co-sharers in respect of the property in question have been occupying the property and running their respective businesses therein. The petitioner complains that the Metro Railway Authority has deviated from their initial plan of location of Chinar Park station, and the present location of the station obstructs the property of the petitioner, thereby affecting the business run therein adversely. It is submitted on behalf of the Metro Railway Authority that the location of the said Metro Railway station shall not cause any obstruction to the property of the petitioner in any manner. But this was the submissions made by the Metro Railway Authority.
So this petition was filed by whom?
Filed by the other.
No, so with regard to the same station.
Same station.
So look, how many writ petitions for change of location of one metro station?
Only so far my information gathered from my client that only 3 persons are affecting for this.
Writ petitions are to be heard together. So let them file reports in the form of because all relates to shifting of the location of Chinar Park.
Right, absolutely right.
That is so. All the writ petitions are to be
only
heard together.
But 2 writ petitions are pending earlier. This one and this one. 2 writ petitions, as I understand.
14614 and this.
This yes. And what during this pendency,
I'm here to receive instruction, Lordship. My understanding is that I just received the brief yesterday, Lordship. My understanding is that, Lordship, this Rail Vikas Nigam Limited, they are supposed to carry out all the construction. So the technical aspect are looked after by them. They should be made parties. Rail Vikas Nigam Limited, I don't think they are contractor.
Yes.
They are all carrying out the instruction. They should be made parties.
This plan and who has changed this
that construction is perhaps probably. Although I am not yet received any information instruction from Metro Railway.
And prepared by whom?
I think RVNL is the concerned party. They should be RVNL. Kindly, Lordship looks into the page 68, Lordship. They have made representation to the RVNL also.
Prepared the plan. Which authority has prepared the plan?
That I will get instruction.
Which authority has taken a decision?
That I will get instruction, Lordship. They have also made representation to the RVNL at page 68.
Since they have
made replace, why are you not implementing?
Yes, they should be implemented as a area of
the
parties.
particular Lord, the Metro Railway, the Vikas Nigam Limited, is the
Rail Vikas
contractor.
Nigam Limited.
He is the contractor. Only the relevant parties as person number 3.
They are independent, I think.
He is to take the decision. He has taken the decision.
Mr. Raut, if you implement them, if they come, what
We
difficulty
can-
will
we-
be having?
Yes,
But
yes,
if
sir.
after all, at the end, I find that a necessary party has not been implemented, for that
No,
ground.
that Milord, I can Milord, I can
That
Milord
is
add
why
the
I
at.
that is.
But
So if
response
it
number
is found that he is a necessary party, non-implementing, you know the consequences of that.
he is not.
It's after all you who have to decide whether to implement or not.
No, I will implement. I will implement. Response number 3 is the Milord main contesting party. The general manager, Metro Railway Authorities.
RBNL.
RBNL is the
Rail
contractor.
Vikas Nigam Limited.
The learned advocate
Another matter fixed before court number 10, my lord.
After that you come because there are
Yes.
matter is
I am not.
This is
and I
for us
think
going on
cooperative
pursuant
matter
to
is
the
also fixed.
order of the Honorable Division Bench presided over by Acting Chief Justice, I think. Now, what I came to know from the news, this construction is going on because there was dispute between state and
report নিয়ে আসতে বলছে report নিয়ে আসবে
To complete within a certain
Okay.
Respondents were all served. The government pleader, we have given notice just now. And
The performance.
were directly served. Government pleader.
No, yes, sir.
We have now, Lordship, what has happened here is like this. There is a lease. The petitioner is a long-term lessee from 1960 of a property for factory purposes, cotton mill in suburbs. Now, my lord, there's a clause that right of sublease with consent, which consent will not be unreasonably withheld. The private respondent is same ownership. Now, my lord, they have a jute mill in Howrah proper, city proper. Now, the holding company got a special consent in written consent from the Land Reforms Department, saying that you may, instead of a cotton mill, you can start business in jute. That is long back, 15 years back. So we've set up a jute park in our factory. Now, so we are running a jute park in the name of the petitioner, and the jute mill in the name of the group company. Now, the group company, pollution issues arose because the heart of Howrah, the conditions became so stringent for consent to operate being renewed that it was virtually basically a closure. So they approached the state government that it is not possible to run the plant. Now, then we want to section 4B, permission to use it for other purpose. The state said you must set up a jute mill somewhere else equivalent with the same machinery, same number of employees, then we can give you permission. So I have a jute park where there are several jute units. So it is agreed that they will set up their jute plant, their jute mill in one of my jute mill plots, same size, same number of people. So this was approved by the state government. They were told that you immediately shift your plant machinery so that we can go and see. They do it. The Land Reforms Department comes and takes inspection and gives a confirmation from BLRO to the DLRO. This has all been done. Now I need a consent for the subletting. Otherwise, I am in default.
Consent for
to sublease to my group company, because my lease contains a clause that with the consent without which will not be unreasonably withheld. So now the Land Reforms Department secretary to the government of West Bengal in writing has confirmed that such a consent has already been given. And they write to the secretary Panchayat division, it is given, just issue it to me. But it is lying stalemate. And we are writing letters after letters. Lordship, just see the clause in the lease deed, page 22, it starts at 25, and I'll come straight away to the 22 at 25, Lordship, clause at the second last, clause Roman 6.
Yes.
That the lessee shall not transfer or assign the demised land or any part thereof without first obtaining the written consent of the lessor, and such consent, however, shall not be unreasonably withheld in the case of a respectable responsible person. Now, my lord, there are all these correspondence about this one shutting down. Kindly come to page 44 straight away. Page 44. The Land Reforms Department writes to another department, Rural Development Department, page 44. With reference to subject noted above, that is the matter pertaining to long-term settlement under section 4B2 of Kajariya, that is the private respondent.
Page
for
40.
Development, page 44.
44, yes.
15th April 24.
Yes.
And yes. Subject is matter pertaining to long-term settlement under section 4B2 in favor of Kajariya for development of residential township on 2.076 acres. Of land under condition that the company will set up unit in Barshul Moza.
That is in your property.
With reference to subject noted above, I am hereby directed to inform you that Kajariya Yans, located at Shibpur on 2.07 acres, has been closed since 2013 on an order of the Pollution Control Board. KYTL has decided to shift its factory on larger land, 3.9 acres of land of Shaktigarh at Barshul Mauza out of 23.86 acres of land leased out to Shaktigarh by your department.
You are Shaktigarh.
I am Shaktigarh. Your department had also given NOC to Shaktigarh for usage of leasehold land for jute processing marketing. You are therefore requested to kindly send NOC in respect of issue of assignment of 3.996 in favor of.
Now you want this NOC.
In terms
NOC
of
is awaiting.
In terms of clause that 2.6 at page 25. This is really a formal in nature, but I'll be in default because as per there are
view of that clause.
Though there are letters, Lordship will find page 42 that inspection done. They've confirmed that KYTL has set up its plant is running, but that formal document is required of consent. Page 42, that is the BLRO to the DLRO. The last six lines of that page 42.
You was engaged in this matter. Could you take instructions? What appearing?
Just received the brief from the GP office. I am appearing late by.
Long back.
I have received just now, my lord. I am appearing late by Mr. Shishanu Bandyopadhyay. I have already.
Where is Mr. Bandyopadhyay?
I have informed and just rushed.
Where is Mr. Bandyopadhyay?
Lord, he is coming. I have informed his office and come.
Ask him to come. I'm passing it over Mr. Mitra. Ask Mr. Bandyopadhyay to come. Yes, call the next matter. আর একটা 2 PM ছিল না ওটা বোধহয় পরে আসবে ঠিক আছে কল দ্য কোঅপারেটিভ ম্যাটার
Number 126.
None appears for the petitioner at the time of call. Must have no
Number 127.
For the petitioner.
Yes. Yes, what is this matter?
My lord, I am challenging an administrative order passed by learned ARCS Paschim Medinipur.
Yes. What is the order and the challenge?
Yes, my lord. Kindly come to the page 60, my lord.
60.
60.
Yes.
ARCS Paschim Medinipur.
Yes.
The dispute case filed is placed before the learned ARCS Paschim Medinipur. Next, last court says in respect of the counterclaim must be submitted before the pronunciation of the award and judgment. Since the submitted counterclaim has been accepted for further hearing as per law by the arbitrator in the dispute case. My lord, here a dispute case was initiated before the learned
You are challenging this?
Yes, my lord.
Yes.
I am challenging this. A dispute case under section 102 was initiated before the learned ARCS Paschim Medinipur. As per according to section 103, he had appointed one arbitrator for adjudicating the matter. There is no provision for counterclaim in our Cooperative Societies Act. even if there is a provision for counterclaim in CPC also, CPC, but in our Cooperative Societies Act, there is no provision for counterclaim. Next is they have the defendant of the instant dispute case had filed
What happened on 23rd of December 2025?
I'm coming. Kindly come to the page 30. The defendant had filed additional written statement.
No, what happened on 23rd of February 2025?
Actually, I appear on behalf of the respondent with my junior. My lord, on 8th January, it was, my lord, fixed for hearing. So, my lord, this application is premature. My lord, once a dispute case is filed, and my lord, they have to, my lord,
According to him, there is no provision for filing any
my
counter.
lord, yes, they filed a written statement with their claim, not counter. That is not a counter claim.
In a written statement, if a claim is made, that is a counter claim.
Yes, my lord.
That is nothing but a counter claim.
That has to be. They have filed a objection. That has to be adjudicated by the.
There is any provision to file. Whether there is any provision to file a counter
My lord,
claim.
the arbitrator is.
Objection is
Sir,
being
I
made.
bow down before your lordship, but my lord, the thing is that the arbitrator has to adjudicate the matter first.
If there is
Then
no provision for adjudication, Mr. Raj, that will
my
be
lord,
only...
arbitrator may my lord pass order in his favor,
No,
accepting his contention.
My lord, counter claim is a separate claim.
They come when before the matter
It is be accepted. That decision is under challenge.
My lord,
If there is no provision, could not have been accepted.
My lord, a person, my lord, a party may
That's
have.
the end of the matter.
My lord,
Please show me that there is a provision for
no,
filing
my
a
lord,
counter claim.
a party may file any application, my lord, whatsoever, but that if they are aggrieved by that order, they have a.
They are challenging this.
My lord, they have to prefer an appeal before the authority.
No.
If it is divorce, the provisions 226 can be entered.
My lord,
Even if there is a
that is a settled law, my lord. I bow down
that is
before your
well
lordship.
settled. You are aware of.
My lord,
Please show me that there is a provision in the statute for filing a counter claim.
My lord, that application was filed, that written statement was filed, that was mere file, and that was, my lord, fixed for hearing. And at this stage, they have come before the court.
Not only fixed for hearing, court fees were directed to be paid.
Yes.
How could this be done if there is no provision in the statute?
My
Show
lord,
me the provisions in the statute for filing a counter
my
claim.
lord, they are the plaintiff, since the plaintiff, my lord, a society.
You whether there is any provision for filing a counter claim.
My lord, that is not a counter claim. Kindly, they have
That is a
satisfied your
counter
lordship.
claim.
That is not that is a written statement, my lord.
What is the counter claim?
My lord,
What is the
Yes,
counter
we
claim?
can order
Under
a
what
special
provision of
counter
a statute there is a
I'm
provision
the order
to file
to
counter
the
claim?
instruction taken.
If you are not ready, I can give you time.
My lord, I can take instruction. I can take instruction, my lord, in this regard.
Please take instructions. And who is for the private respondent?
Last case they have appeared, my lord.
Who appeared?
Pingol Bhattacharya.
Where is he?
I have served.
Sir, you are appearing for the assistant registrar of
My
Cooperative Society.
1, 2, 3. 1, 2, 3. 1, 2, 3.
The learned
But I am appearing for the petitioner.
Next Tuesday.
This is the affidavit of service.
Yes.
My lord, I have got the brief just now, my lord. If you lost,
Who are you?
I am for the, my lord, respondent.
Respondent. Which
My lord.
respondent?
My lord, he is
Respondent
appearing
number
probably
2.
for all the respondents. The
Yes.
subject matter of the writ petitioner is.
Your
What is
lordship,
your
kindly-
challenge?
My lord, subject matter of the writ petition is this. There is a provision made under the purchase policy issued under the notification number 10,500 F of 2004 dated 19th February, November 2004.
Double.
State
Please double.
page at 182 of the second volume.
So what is the provision made in the purchase policy?
My lord, there is a relevant page is, my lord, 187. Subject to the provision of Rule 47B of the State Government Department Direct. My lord, got it? 187, 47A. After Rule 47, insert the following rules. This is the amendment, my lord, which has been proposed, and amendment has already been effected. Subject to the provisions of the Rule 47B of the State Government Department offices undertaking cooperation such as
So
complaints.
what is your challenge?
My lord, the challenge is that there is a specific that is, my lord, now, my lord, all registered SSI unit of the state are to be given 15% price preference.
Yes.
That has not been given in NIT. That is number one challenge. And second, my lord, there are certain others, my lord, this is the price preference has been given to the cooperative. That has not been given. My lord, I am coming to the NIT.
Yes, Mr. Mahato. are you
My
ready?
lord, the claim of the petitioner is not sustainable because he is relying upon the circular that is not applicable in this instant case. My lord, with regard to the 15% preference, my lord, in the second page, my lord,
Yes.
unfortunately, my lord, in 113 I have got the instruction. It is not signed by the
A
official.
copy to be given to me, my lord. At
Yes,
least.
yes, I shall.
Mr. Mahato, please give him a copy. I am keeping it for tomorrow.
Yes,
Tomorrow or next Tuesday?
next Tuesday.
Tuesday, my lord.
Next
Next
Tuesday.
Tuesday. Uh,
And my lord, the my lord, the result of the NIT is to be abide by the result.
No, nothing.
My lord,
Mr.
পরের দিন আরেকটা রিপোর্ট করিয়ে নিয়ে
My lord, in this matter, my lord, I am appearing for respondent 6 and 9. The added respondent.
Yes.
Lord, I am the successful auction purchaser. I have purchased one property which was valued rupees 60 lakhs 1,000 and I have deposited 60 lakhs rupees.
Yes.
And that period of time already been over 9 months has been lapsed. But I have neither given the possession nor my money has been transferred, my lord. That is my grievance. And last occasion, there was a direction to take a bring a-
Instruction.
We had prayed for instruction, your lordship, because it was holidays were
You have not
commencing.
received.
I haven't received as of now, your lordship.
No, no.
At least a week's
There
time.
the Vishwabharati Credit Society was not made party because I'm only manager. I'm
This
made
is for
party.
the society, your lordship. I am for the authority who was directed
the
to take,
authority.
who was directed to take instructions, your lordship.
When?
So,
Next Tuesday?
okay.
The learned advocate appealing for be upgraded. It may
I
go up, it may go down.
Well, I am suffering from since 9 months, my lord. After depositing the
This
money.
is the first day which has been listed, it has been taken up, at least before me.
My lord, my lord.
Yes.
Lord, I have received it,
Yes,
my lord.
Mr. Bandyopadhyay.
I require some time to take instructions in the matter, my lord. My learned senior will correct me if I'm wrong. There's no pressing urgency. So if a fortnight may be given to me, my lord.
Mr. Bandyopadhyay, that may be one way of looking at it, but the other way is a writ petition has been filed, copy was served, no one appeared for this date prior to recess. When Mr. Mitro moved this,
Yes.
I requested him through his learned advocate on record to take instructions who have been briefed in this matter. Then he went and served another notice. This is not the first time. So then he served a notice.
No,
My lord, it was served upon the officers.
Prior it was served.
Yes.
On the officers.
On the officer.
On the officers, not GP.
Government leader, it was not
Never.
served.
Today, first time.
My lord, Friday, the matter was mentioned with leave of Mr. Mitra. Friday.
No, initially the copy of the writ petition was served upon in the office of the government pleader, yes or no?
No, my lord, because they
Why?
don't, my lord, because they
Today in the recess, first time.
my lord, they don't accept the petition without the date being inserted. The matter was mentioned before my lordship on Friday. And my lord,
No, that is for upgradation.
no, my lord, they don't accept without a date being given in the list,
When you
my lord.
filed this writ petition was filed on 8th of December
Yes, my lord.
2025.
My lord,
So you
we
should
went
have served a copy upon the government pleader.
my lord, we went to serve. My lord, I accept.
Should have served.
Well, the letter, I found the fact from the letter itself that it has been served on the clients. This petition was served on the clients. So perhaps
The respondent.
mean the department and the authority.
Now, Mr. Bandyopadhyay,
They should have informed,
what
but
is the purpose of serving the respondent?
well, they had ample time in the meantime. Yes, perhaps they.
From December 8th,
No, blood.
the respondents have not.
Perhaps
also
they sent the
contacted.
file here and there, Malad, then Malad, it has been, it appears so. So, Malad, I'll take care of it. Let me come back in a fortnight, Malad.
Maybe with regard to this matter, in most of the matters, states are going unrepresented, I'm telling you, in spite of such.
Well, that I'll Malad, take up with the learned and government leader, Malad.
May I ask Mr. De, Mr. Mahato, they are appearing. Most of the matters, I'm requesting them to appear to take instructions. Most of the matters, state is not represented. So that is.
But that part I'll take stock of that
and,
part.
With regard to this, Mr. Mitso, please indicate the issue.
May I just tell?
To enable Mr. Bandyopadhyay
What
to take
else?
instructions
My lord,
with regard to that.
my group company, respond number 3, KYTL was having a jute mill in Howrah proper. Their factories had to be closed down because of PCB order. I have a lease from 1960 where there is a clause that I can sublease assign with the consent of the landlord, which will not be unreasonably withheld. So KYTL is given permission to shut down with the PCB on the condition that they set up a plant in my jute park.
Mr. Bandyopadhyay,
That has
you
been
can
done.
straight away come to page 44.
That has been done. They have inspected that KYTL has set up the plant. Respond number 3. If you see the letter, subject matter
Read
that
this letter,
matter
the subject, and Mr. Mitro's requirement now is the last paragraph.
Your last
NOC.
Yes.
In favor of respond number 3. Yes. But that is the only part I could read in
my favor.
In his favor, so that he can operate.
Yes, so that he can operate, and
they are operating already.
Stated in the first paragraph of that, and the subject has been mentioned. So this is in short on which you have to take instructions, because this is long awaited, for which a factory is not being.
No, they are running it. They are running it, but I am technically in default because I have not taken the consent, though that is there. Technically in default. Running the factory was a precondition. So they come and inspect. Land Reform Department, that is page 42.
So there may be a technical defect at a point of time. He may be hauled up by saying that there has been violation
of the lease deed. That is my
conditions of the lease deed and other things.
And then that can be
Because
just.
this was permitted to run in his property. The private respondents were allowed to run. So this is the sum and substance of the writ petition. So you can take instructions. When can you come back?
But a fortnight. Kindly gives me a fortnight. Since they are already running, Malad.
But please, any penal measures in the meantime. I'm not passing any
But
formal measures.
they're running in any event.
Yes, the
Wait,
if you want, you can file a report also.
my lord, I'll just.
If they give their consent, then I don't.
Yes, my lord, it is just a yes.
Because this is the only issue, factory that is being run. And lease deed also
But if there is
provides
no
for-
other issue, probably I'll come back with a positive instruction.
Yes,
Otherwise,
because lease deed also
it should-
provides for this assignment,
yes.
but with your consent.
2 Roman 5 years.
But with your consent.
Roman
So for
five,
that,
six.
they. Yes, call the next matter. Yes.
Item number 19, Lordship, I beg to appear on behalf of the petitioner, Lordship. I
But,
declare Mr.
but,
Prabhupada Chatterjee in this matter.
My lord, I am for the petitioner, my lord, in this
Yes, what is
matter.
this matter?
My lord, this matter, I have challenged the penalty imposed upon me by the BLLRO, the penalty of rupees 50,000.
Yes.
Lordship, kindly come to the impugned order.
Yes.
My lord, Lordship, kindly come to
Page.
Lordship, this collection report and the impugned order, my lord, kindly it starts from page
Which page?
page 24, 25, 26, 26, my lord.
26.
26. Lordship, kindly come to 33, page 33. Now, this is the collection receipt. Now, this was received by them. My lord, thereafter I made a representation subject to prayer for unlocking my e-challan of the vehicle, a number such and such. I would like to inform you that I am such and such of my vehicle being registered number such and such has a valid driving license and the weight and in the challan number such and such. Now vehicle was coming from. Lordship, kindly come that it was coming from
Pursura.
when the Chonditola, it was Pursura to Chonditola. When it was coming from Pursura, when it stopped at Chonditola. Thereafter, Lordship, that he was obstructed there. According to them, the vehicle is covering 305 CFT sand. So lock my vehicles and issued the e-challan. But then this was allowed. On the very next day, when it was coming, then it was not opening. His entire when after this downloading, when the vehicle came for uploading the sand again, this entire portal was not working. That was my my grievance here. My lord, I was coming from Chonditola, carrying the sand and obstructed at Chonditola. I was coming from Pursura. Near Chonditola, I was obstructed, and thereafter the challan was issued. I paid, and I was allowed to carry forward. Thereafter, when I left, and when I again reached to Pursura for reloading my vehicle on the next day, this was not allowed by them. This portal was not operating. So now, Lordship, this penalty itself is illegal, as well as, Lordship, the portal, operation of the portal must be allowed by them. That is my grievance in this writ petition, my lord.
Yes. What is your allegation against the private respondent?
No, there is no allegation. But
There is as such no
There is
allegation against
there
us.
is no
We have
allegation
paid the
against
amount
private
that
respondent.
keep as reflected in page number 24.
The mining.
Oh.
He is the operator of
Yes.
the mine.
I am the carrying vehicle, man.
Lordship, only one document also.
Instruction, my lord. And the second page, my lord.
Yes.
The last paragraph before, last but one paragraph, which was allowed the vessel to carry only quantum of 280 cubic feet of sand. And he is carrying
382.5.
82.5, and that is 102.5 feet more. For this reason, was what is this? What's your paying for?
Where is the rules? West Bengal Minor Mineral Concession Rules.
My lord.
Well, my land junior will be referring to.
এটা দেবেন তো জোর
আমাদের কাছে নেই।
তুই বস আমার তাহলে সুবিধা হবে মামলাটা করতে।
Yes, Mr. Singh.
My lord, may I? এটা দিয়েছি জজ সাহেবের হাতে।
আছে।
My lord, apart from these rules, my lord, there are other rules also. But for the present moment, may I tell you to your lordship that, my lord, the person authorized in this behalf that to, my lord, to scrutinize the entire exercise of this, my lord, the mining operation on road, my lord, he, at the time of,
who is the authority?
But the regular checking, that is, my lord, the district BL and LRO.
Block Land and Land Reform
Yes,
Service.
yes. Now, my lord, if your lordship kindly have a look, second page of this, my lord, the written note, if your lordship kindly have a look, second page, clause number 9.
Well, may I get a copy of the written notes, my lord, so that it can.
Not the written.
Not the written note, but the
instruction.
instruction.
Not the written note, the
Yes,
written instruction.
instruction with regard to the facts. Sometimes, my lord, we are not so efficient, my lord, so that all the instructions, my lord, we can tell, my lord, without this, my lord, written. So, the clause number 9, the undersigned being the BL and LRO Chonditola 1 has been engaged by the nodal officer, that is SDL and LRO subdivisional. Srirampur, as a checking officer for the purpose of enforcing the aforesaid rules and regulations through West Bengal, my lord, that is my lord, Mineral Development, my lord, the Transport Corporation Limited, now it is there.
Yes.
Now, proper enforcement module. Now, if your lordship kindly come to my lord, the third page,
Yes.
as well as the last page of this instruction.
Yes.
My lord, the second paragraph.
Yes.
On 1st December 2025, that is after that, my lord, the interception of the vehicle, nothing has been seized on the, so far I recollect, vehicle intercepted. Now on 1st December 2025, Sri Arup Deashi, possibly my lord, husband of the petitioner.
Yes, yes. Onup, this is Onup, yes.
Anup,
Husband of the petitioner.
husband of the petitioner, came to the office and requested to unlock the vehicle. Unlock means, my lord, that is, my lord, it has been a locking, and that rule is there. And my lord, with regard to, my lord, to some extent, blacklisting, I can say. That so that
Physical locking?
No,
or the
no, computerized. So that that next e-challan
will not be generated.
will not be generated.
Yes.
With regard to that mining purposes, that particular vehicle.
Not physical locking.
No, not physical locking. No physical seizure, no physical locking. He can move his vehicle anywhere, any place, save and except that this facility will not be generated. Now, later on 1st December 2025, Anup Desai came to the office, requested to unlock the vehicle, as well as submitted a prayer for unlocking of truck number such and such, mentioning that the truck bearing number such and such was carrying only 305 cubic feet, that is not overloaded, for which action has been taken, and he is unable to pay the penalty money, and also requesting to unlock the vehicle as soon as possible. Along with the petition, he also submitted a slip of computerized weighbridge of a gross weight, something dated 21st of, it should be December 25.
Yes.
21st November should be. Which is after,
should be November.
Yes, after the locking the vehicle, 540, what it may be. In any event, Mala, I am drawing your lordship's attention to the fact that he has already made a representation to the person concerned, who, my lord, by virtue of his authorization, who, my lord, acted in this way, and the challenge is his action. Next, undersigned has forwarded the said letter to the ADM and DLLRO Hooghly, higher authority, and also the nodal officer here in HDLRO Srirampur by memo number such and such of 3rd December 25 for their kind perusal, as the case ID being number such and such, in relation to the vehicle number such and such, which has been forwarded at the end of the nodal officer Srirampur enforcement module. So, my lord, may I submit one thing, my lord? When, my lord, he has submitted one representation stating certain facts according to him, and certain facts according to the nodal officer, that for which the action has been taken, all these things can be looked into by the person concerned, who is, my lord, already before whom it has been forwarded within a period.
Oh, who is that authority?
Well, that is, my lord, it has been mentioned here in ADM and DL and LRO. I think he may be the party herein. Should have.
Yes, Mr. Chatterjee, what do you say?
Malad,
Yes.
if
Response number 5.
It is falling from Mr. Sen, and if your lordship accepts that, if your lordship delegate this matter to the concerned authority?
Because Mr. Chatterjee, only one thing,
No, no.
this offense you have admitted. Your only stand is that you cannot pay that penalty.
My lord, offense I have not admitted, my lord. The thing
Yes,
is that
the tenor of the
situation was such.
representation says so. Tenor of the representation says so. You have not denied that.
My lord, I
Because,
have only stated the facts, what has happened, my lord. Kindly
Yes.
come to the representation. My vehicle registered number such and such has a valid such and such challan.
Mr.
number
Chatterjee, it
such
has
and
a
such.
valid challan,
Yes.
but for 280 square feet, cubic feet, and you are carrying more than 280 cubic feet.
But
That's the
wait,
violation.
my lord, here the BLRO caught my vehicle and locked e-challan according to the vehicle is covering according to them. It is their version I have quoted, my lord.
Yes.
It's according to them, the vehicle it is 350 CFT sand, but I have 280 CFT e-challan. I can afford the penalty. Now, possibly it's the result of the bad drafting.
Mr.
previously.
Sen, Mr. Chatterjee, please give me a minute. Mr. Sen,
My lord.
this measurement, there is some document on which he has to put his signature on that.
Yes.
At the time of measurement, where is that? When you have verified the weight measurement,
Yes.
so it must be in his presence.
Yes. And,
I think he's authorized representative in the
sign that. Show me that.
Lordship, kindly come to page number 2 of the written instruction. Page number 2
of the
last. Yes. That is, my lord, the last paragraph.
Yes.
Page number 2. As the quantum of sand seemed to be more than that of the permitted quantum as mentioned in the challan, in presence of the person in charge of the vehicle, that is the driver of the vehicle, a measurement of the loaded compartment was conducted to confirm the actual quantity of sand which had been carrying by the vehicle, and as per the measurement, length of storage compartment was 17 feet, breadth was 7.5, and height of loaded sand was 3 feet. As the truck was fully loaded, volume of the sand came to a quantum of such and such. This is a measurement, my lord. And the cubic feet came 102.5 cubic feet was more than the permitted quantum. Such irregularity, which was against sub-rule 4 of Rule 5 of West Bengal Mineral Prevention of Illegal Mining Transportation, a separate rule, Lordship, of 2002. And then it was informed to that, my lord, the person in whose possession the vehicle was, that is the, my lord, the driver. And so, now, my lord, may I tell before your lordship, all these facts, my lord, are to be looked into by that person.
Sen, I follow that. But when you take this measurement, there has to something in writing that he has also accepted that.
Sometimes, my lord, they may not accept. Sometimes they do not accept.
That is the violation of
What is the procedure? How do you verify this? You don't take the signature of that. Then they will go and deny that, no, it's not that.
Signature, my lord, normally, my lord, a request is made to the person concerned in whose possession the vehicle it was found,
That's
or
the
it is
driver.
found. That is the driver.
Yes.
So,
So, did he sign? What is the usual procedure? You detect or intercept a vehicle.
I know,
According
but
to you,
what-
it might be you ask him to produce that challan, then you can take the measurement. Now, when the measurement is being done, there must be some document to show their signature.
True.
Otherwise, they will, once you have recorded, they will go and say,
but this
because the
is-
vehicle has not been seized,
this
they
is
will
not-
go and say, no, this is not the measurement,
Yes.
this was not that.
Yes, they may say, let them say so before the authority, because he has submitted one representation. He has submitted one
Where have you
representation.
denied in this writ petition? This was the measurement, show me.
Lordship, I have denied it.
Where? No, what is the length and breadth of that vehicle, and what was the height? Show me in the writ petition. What have you stated?
Lordship, kindly come to page number 24, Lordship.
Not 24 in the writ petition ever meant. Show me how have you proved that it was 280, not 382,
Lordship.
not 305. What was the length and breadth of the vehicle which was carrying sand? You have not mentioned anywhere in the writ
It is not there. It is not there.
So-
Well, admittedly, that
So
that
you have not
abutment is not
disputed
there.
that. On facts, you have not disputed.
Kindly come to paragraph 5, Lordship.
Yes.
Your Christmas states that on 5/12/2025, the relevant authority issued a challenge such and such based on stock permit on such and such, duly granted by the ADM and PA.
Paragraph 5.
The challan was system generated, transparent,
to
and
mention
verified and free
No,
from
this
any
is on
secret.
facts. What was the challan for?
Yes, your lordship.
Yeah, they have given, sir.
My
They have
lord,
measurement of
lordship,
your vehicle. Have
Sorry,
you
what is
disputed the
missing is
measurement
this.
of your vehicle?
Measured, Lordship. My allegation is that, Lordship, they even not measured, Lordship. What they ordinarily doing, Lordship.
I accept that, but I'm asking you,
Yes,
what
sir.
is the measurement of your vehicle? Please,
Taken place, Lordship. That was not be taken, even, Lordship.
I accept
No, 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 no.
that. I'm asking you, what is the measurement of your vehicle?
Lordship,
Or the
I
vehicle
fully
number?
agree. What is fallen from your Lordship? Your Lordship is asking us to demonstrate the whole thing.
Yes,
Lordship,
yes.
yes, if your Lordship
Because they
wants,
have
I will
taken
come
this
up with a
measurement.
supplementary
If you
affidavit.
do not dispute,
A
that's end of it.
mathematical measurement is there.
I will come up with a
Because your
supplementary
vehicle, you
affidavit.
have a
Lordship.
vehicle
Kindly give me a
number.
liberty, madam.
That the carrier measurement you cannot dispute. What are you saying?
Lordship. But the capacity of the vehicle has been mentioned in my blue book, Lordship. That is I have annexed, Lordship.
Capacity
is
of
one
the
thing.
vehicle is something else.
Capacity is one thing.
But my Lord,
That will be on paper.
Yes.
But what was physically?
But apart from it, Lordship,
And
I can
and not
what
only
they have
that,
done, Lordship, they
So you kindly allow us, we'll come up with a supplementary affidavit, my lord.
Let them go.
even Lordship, so far the law is
Let the authority decide.
yes.
Lordship, kindly show that this is only showing in the system generator. Even if a fine has been imposed, we have to communicate. It's appealable.
Right,
We can appeal the fine.
now it has been forwarded to the ADM.
Yes, yes, yes.
The petition.
Respondent number 5.
Six-wheeler vehicle measurement and
So who has come? The owner of the vehicle.
Owner of the vehicle.
The petitioner
I
claims
paid
to
and
be
button
the
is
registered owner of vehicle number WB 17. To gap the linkben 6464, comma a six-wheeler goods vehicle.
Lordship, in Facebook,
No.
we have stated that the CFT
Full stop.
are included.
The petitioner claims that the said vehicle is used for carrying sand on the strength of valid system generated e-challans. On November 21, 2025, the aforesaid vehicle of the petitioner was carrying sand on the basis of on the basis under a e-challan and on the basis of a e-challan for 280 square feet of sand, and such vehicle was intercepted at where it was intercepted, Mr.
My lord, this was intercepted at this one, Chonditola, near Chonditola.
Chonditola.
Was intercepted at Chonditola or near Chonditola? Was
This was
intercepted
at Chonditola.
at
Chonditola.
Within the jurisdiction of BLRO Chonditola, my lord.
Was intercepted within the jurisdiction of Block Land and Land Reforms Officer
Chonditola 1.
Chonditola 1. First up. A penalty was imposed, alleging that the vehicle in question was carrying sand more than the permissible limit. Full stop.
More than the permissible limit as it appears from the e-challan produced.
More than the permissible limit as per the
E-challan. Because otherwise, permissible limit as per Motor Vehicle Act.
Yes, yes. They are on the Motor Vehicles Act.
Yes.
Permissible limit under the e-challan.
E-challan.
Resulting in locking of the vehicle in the system.
In the system,
First up.
restricting from further generation of e-challan.
Locking of the vehicle, restricting further movement of the said.
Restricting from further generation of e-challan for this.
Restricting
Yes.
further generation of e-challans for the purpose of transportation of sand.
Good.
Full stop. Paragraph Mr. Chatterjee, learned advocate appearing for the petitioner, submits that the petitioner was carrying sand well within the limit permitted by the e-challan. Full. Petitioner submitted a representation dated, what is the date? 1st December.
1st
1st
December
of December 2025.
Yes.
Before the respondent authority, praying for unlocking the vehicle of the, praying for unlocking the system, thereby permitting generation of e-challan for the purpose of transportation of sand by the said vehicle. Paragraph. Mr. Shane Larned, additional government pleader, additional advocate general, submits that after interception of the said vehicle, the measurement of the volume of sand was taken, and it was found that the vehicle in question was carrying sand more than the permissible limit under the e-challan. He submits that necessary papers have been forwarded to the additional district magistrate and district land and land reforms officer, Hooghly, for taking a decision with regard to the prayer of the petitioner for unlocking the system to enable generation of e-challan. First up, since there is a dispute on facts as to whether the after hearing the learned advocates for the respective parties, this court finds that a disputed question of fact as to the quantum of sand that the vehicle was carrying is involved in this writ petition. First up, such a dispute is to be left, is best, can be decided by the concerned authority after considering the materials available in record. In view thereof, WPA number such and such stands disposed of by directing the
Respondent
additional
number.
district magistrate and district land and land reforms officer,
Respondent 5.
being the 5th respondent, to consider the representation of the petitioner for unlocking the system to enable generation further future generation of e-challan for the vehicle in question. First up, to consider the
instead
and
of
to dispose of the same
may I tell?
by
Instead of
passing a recent order after giving an opportunity of hearing to the petitioner or his authorized representative and any other authority who may be a necessary party for the purpose of deciding the dispute raised in the representation dated 1st of December 2025. It is, however, made clear that it will be open to the petitioner to produce relevant materials.
And
in
Lordship, if they
support of
say, my Lord, only thing, Lordship, they are saying that they have done the
please,
formalities.
in support of his claim, and the materials that may be used by the authorities against the petitioner should be supplied to the petitioner well before the date of hearing fixed for such purpose. The reasoned order shall be communicated to the petitioner as expeditiously as possible, but positively within a period of, Mr. Sen, how soon? Because the vehicle, the business is being hampered. So,
No, my lord, 3 weeks from the date of communication of this
within
order.
a period of,
Enter exercise, 3 weeks from the date of communication of this order.
can you complete it by the end of January?
I think, my lord,
Business is being closed.
No.
That is only.
no, business, his vehicle is not attached, neither she's not such an order
He
passed.
cannot generate.
Only thing, what,
Legally, he cannot apply for sand mining.
yes, but there are other,
That's the only
a
business.
truck or lorry is being used for many purposes.
That is there, but কি বললাম? Within a period of 3 weeks, within a period of 3 weeks from the date
We
of
want to generate
receipt of-
revenue for Mr. Sen's
from the receipt of a server copy of this order, along with a copy of the representation
Yes.
dated
Wait.
1st of December 2025. First of the respondent, the other respondent authorities are directed to forward all necessary materials and papers before the fifth respondent in connection with the matter in issue before the fifth respondent forthwith, because other authorities,
Yes, yes.
papers
Nodal officer,
and
other
Mr.
nodal
Sen,
officer.
whatever documents, this
Whatever.
report and anything
Yes.
which you want to rely against them,
Oh, yes, yes.
measurement,
Yes.
they have to be given a
Yes,
chance.
yes, yes.
Mr. Sen, what you were saying? I asked you.
No,
to
I
stop.
think but everything covered.
Yes,
Subsequently.
Mr. Chatterjee, anything you wanted?
No, no, it is covered now. I wanted, my lord, the
So far,
documents
our
we
part is
furnished in
concerned.
advance.
First, permit me to complete. Thereafter,
Yes,
if
my
you
lord.
have, otherwise,
so,
it gets distracted.
Lordship, so far our part is concerned.
Who are
Kindly,
you?
Lordship, this is the respondent who have sold the sand to the petitioner.
Not to the petitioner, I'm carrying.
Yes.
He's the owner of the registered vehicle.
Yes. Now we
Who are
have
you?
sold the sand.
The mine, owner of the mine.
Owner of the
They are
mine.
the
Yes.
Now, Lordship, kindly come paste, kindly record my submission that we have only transferred 280 CFT to the
No, no, no.
particular case.
What locals?
No, no, no.
they are the party.
This matter is concerned what locals.
Kindly come paste.
Recording is submission.
Yes, 24. That is the Prasanta Kumar Hait, who is the mining Lordship, the lessee.
All these documents can be produced there.
No, no, what is the problem?
In
Right?
support of.
Mr.
Very
Sen,
good.
he is appearing,
Well,
otherwise he cannot justify his presence. Learned advocate
Yes.
appearing for the
Well, may I?
for the 11th respondent submits
Well, may I leave?
that the 11th respondent only authorized the petitioner to carry sand within the limit permissible under the e-challan. আচ্ছা তাহলে ওইখানে না, you are not required to attend the hearing.
No, I have. So only my submission that I have only
That I have recorded.
transferred the.
Call the next matter. Service taken on record. Yes, call the next matter.
In this matter, my lord, Mr. Pantu Devra is appearing for the state matter, my lord.
Yes.
Please not pass it over, my lord.
Why pass? You are here.
Engage in court number 5, my lord. Can you pass?
You are here. You are also in the state panel.
Yes, my lord.
Mr. Devroy will join you. Yes, what is this matter?
On a may I submit one instruction, my lord.
Who is for the petitioner?
I'm for the petitioner.
Yes, yes.
The same issue, Lordship?
On a may
Same issue.
My lord, may I submit, my lord, instruction?
The same issue, my lord, the penalty.
Kindly see, my lord, second paragraph, my lord. The instruction.
No, where is your representation, Mr. Chatterjee?
That is on page number.
My lord,
Number?
this is in page number.
There is no representation.
There is no representation. Then what are you challenging?
My lord, the action, my lord, this penalty has been challenged, my lord.
Cancelled, Lordship. They have
And
not,
Kindly see, my lord, second paragraph.
they have-
Can you see? First page, my lord.
Yes.
First page of the instruction, second paragraph. While planning the vehicle, my lord, since there was no, my lord, update challan, my lord.
So challan was not there.
Challan was not there. Update challan.
Oh, expired challan.
Expired challan was there.
Yes, what was the time of interception? Yes, Mr. Chatterjee, what do you say? It was carrying sand on expired e-challan.
My lord, nothing was given to us, my lord. May I just come back after going through this instruction, my lord?
Page number 24 of my report. There is a challan, lordship.
Challan.
Yes, sir. Challan
Page
is
number 24.
24 of my report, sir.
This was generated, my lord, in 5/12/2025.
That is the
Issue
last
date was
page,
5/12/2025. My lord, top.
Issue date was 5/12/942, valid till 6/12. When the vehicle was intercepted, what have you stated in the writ petition?
My lord, kindly come to paragraph number 5.
Subject matter of the repetition is that, lordship.
No, when it was intercepted on facts, where have you stated?
Yes, my lord. I'm coming to that paragraph, my lord. I'm taking straight away to that paragraph, my lord. My lord, kindly come to paragraph number 5. That
Five,
on
yes.
5/12/2025, the relevant authorities issued e-challan at around 9:45 p.m., 42 p.m. based on the stock permit being number such and such duly granted by the ADM DLLRO, Hooghly. The challan was system generated, transparent, verified, and free from any discrepancy.
No,
The
Mr.
challan,
Chatterjee, what is the time of interception of the vehicle? When it was intercepted, at what time?
Page number, paragraph number 7.
7.
Lordship, but on the valid time, lordship, when it was uploaded.
That's vague. That's very vague.
No, lordship. Then the route, kindly consider the route, lordship. This route, that the duration.
When it was intercepted, it must be giving the exact time of interception.
When it was started from after uploading, lordship.
When it was intercepted, because at the time of interception, it was the e-challan lapsed. It expired.
Yes,
So
sir.
it was your obligation to renew it. Without that, you could not have.
No, lordship.
Lordship, may, Lordship, if the Lordship is asking me, I have understood the time, importance of the timing. Lordship, kindly grant me an opportunity, Lordship, I will come up with a supplementary affidavit stating the timing of the interception. Since it's a case, my lord, no representation is there, I will come up with a
Back the
affidavit.
report. Report ka diye din.
That would be better.
The I record the name of Mr. Debra. Yes, next.
Yes, sir. Item number 21.
Yes.
And for the petitioner, madam, removal of the unauthorized construction over the national highway. Any change?
NHAI.
DM
So DM is the authority.
DM is the authority. He had
Yes.
made a representation at page 36.
36. Yes, Mr. Mahato, what is your
Yes,
instruction?
my lord. It should be considered.
Private respondent served.
My lord, except respondent number 8 and 14. Check in the web-based result matter, there is no demand.
There is no?
remarks, my lord, in the web-based result, my lord. But
Uh,
all of remaining all are sub.
Which is your plot? 787.
My lord.
787.
The petitioner claims to be the owner of.
Well, I'm big, my lord. I'm appearing, my lord.
Yes, yes.
I have gone through, my lord.
Yes,
But
what is your
yes,
submission?
my lord, I have gone through, my lord. Only thing is that, my lord, your lordship is harping on the whether this plot is acquiring by the government or not. As because this is already acquired land.
Right to fair compensation in case of acquired. This is not a.
No, my lord, only thing is that, my lord, the under the Act of 1962, my lord, that is the by which the public land eviction of the unauthorized occupant act.
This is public land.
No, my lord. This is the 1964 Act. West Bengal Highways Act.
1964 Act. Highways Act.
State Highways Act.
Yes.
Now, my lord, even that is not on the state highway. My lord, even if that, my lord, that is required to be, my lord, by way, my lord, if it is, my lord, these acts will also apply in respect of those people, my lord, the right to fair compensation.
Show me that. Which provision?
My
Right
lord,
to
right
fair
to fair.
compensation. Which section? That an encroacher is also entitled to compensation for removal of encroachment.
My lord,
Please show me.
encroacher, this word is not there, my lord.
Sir, state or any highway, can any person construct on that?
My lord, this is not the construction as like the construction, my lord, the constructions like, my lord, this is a makeshift one, but this is a gumti.
Can you do that?
My lord, my lord, this land, my lord, this is I am holding two things, my lord, which my lord, I try to, my lord, I know, my lord, I will fail, my lord, I know.
Occupy? Do you have any authority to occupy
My
that
lord, that
land?
the construction or the makeshift constructions built, my lord, sometime in the year, my lord, but 30 years back.
So now one day you decide that you will make a construction on the main
But this
highway,
is a makeshift
thereby you
one.
obstructing everything.
Makeshift one, my lord, this is a gumti, my lord, they are the artisans. They are the artisans, my lord, and they are, my lord, the
Appreciate all these things.
and my lord,
Show
they
me
are the tribal. My lord, this has been certified that they are the tribal
show
one.
me an authority to occupy, sir.
But
If
this
there
is
is no authority, if you are entitled to compensation, you can approach the authorities for compensation. That's a different thing altogether.
only to, my lord, that in
I'm only directing them to consider, raise all points before the
my
authority.
lord, my
And who is for the state?
But the last someone what appeared, my lord. At that time, someone appeared. তখন বলছিল কি কে বলতো ছিল
Yes, anyone, any junior advocate from the state panel? Any junior member of the bar who is in the state panel? You are, please appear. So don't make.
No,
that
I am,
decision because I have dealt
that
with
has
that.
been done. I think so. Matlab they
You cannot do that. Remove then section 8. Then it's you have admitted that. You have to section 8 is after taking permission you can make construction.
My lord,
It's not post facto.
my lord,
I have delivered a judgment.
my
on
lord,
that.
my lord. That I have gone.
Don't
through.
raise that
That I have
issue.
gone through. My lord. That I have gone.
Affidavit of service.
Yes.
My lord, I'm for Union of India, my lord.
Yes.
Kindly seize my lord's last order.
My lord, I appear for the National Highway Authority, my lord.
You are aggrieved by the
My lord,
amount of award.
yes, I tell
You
you.
have to approach the arbitrator.
3G5. What I just beseech your lordship, I was not properly instructed, my lord, on the previous day. There was no award that was passed. I was wrong in making this submission to your lordship that there was an order and I did not annex this. So, my lord, this is something, my lord, which is coming to your lordship first time. That means, my lord, there was an acquisition process for which, my lord, nothing was being done. I made representation one after another, not being considered. I came before this honorable. This honorable court directed that it has to be disposed of after giving an opportunity of hearing. So, my lord, in that particular matter, my lord, the respondents, my lord, appear and they say that they denied my claim. Some of them, my lord, accepted my claim and my lord admitted my claims also. After that, my lord, they just, my lord, issued this order by stating that you're entitled to get this much of amount, which is at page number 103 to 105. So that is what, my lord, the amount that has been mentioned in the letter. I say, my lord, that is not an award at all. (103) and I'm sorry, my lord, 103 and 105.
Yes, who is appearing for the competent authority? Competent authority, ADA, MLA.
Yes.
Who is
I'm
representing?
happy.
Yes, where is the award? Where is the award?
Lordship, here,
The
Lordship,
payment notice 103 to 105.
yes. Lordship,
So-
here, Lordship, the Land Acquisition Act is not applicable here.
Land Acquisition Act is not applicable, but ADM is the competent
Competent authority, yes, absolutely correct.
So where is the award of the competent authority? I'm asking that.
Yes. Lordship, that was admitted position, the award was declared
Who is
and
for the National Highway.
My lord, I appear for the National
Where is the award?
My lord, since we are the requiring body for the land, the competent authority to give the award, my lord, that is national. That is the Kala under the Act. My lord, in that case, if they are not able to provide, my lord may grant me time. I shall come up with instructions if they are not able to provide, my lord.
Mr. Rai, there has to be an award. Otherwise, this payment notice.
This is my specific instruction and records my submission.
Have you stated that in the writ petition? Please show me that that is the specific case. where
This
they
is
have
only
given
thing that I have got that I have stated in my writ petition. If I request your
it.
lordship,
Payment notice is after that.
this is only the thing. This is only the thing. Otherwise, my lord, I would have, my lord, addressed
Payment
you.
notice is as per 3H, but determination is to be as per 3G. After that determination, this payment notice will
This is
come.
all which are before your lordships. Because I think, my lord, the entire, my lord, process, my lord, this has been a little bit gap in this because of the reason of mine. I accept this, that I could have, my lord, make a prayer. However, my lord, before the authority, but I came before this honorable court at the first instance. After the order of this honorable court, my lord, there has been a recording. If I request your lordship, my lord, to see the order sheets, if they call it an award, my lord, let it be. This is only thing that I have got. Order sheet. If I request your lordship to see, my lord, page number 98 once. This is all. And in fact, my lord, that is there in my favor. By saying that the NHA, the lordship sees the last part of the order, which your lordship will see at page number 100.
Yeah. 100 punta.
This is the award.
Writ petition.
Writ petition.
The additional
Starts from 98 and
That's not the award,
Yes.
sir. Where is the award? This is not an award under 3G. Mr. Royal Honored Advocate appealing for the petitioner submits the true inadvertent.
Madam. In course of
The Lana
I am for the
Mala-
petitioner.
Mr. Manoj Malhotra appearing for the state. I pray for 2 weeks time because his mother yesterday passed away.
who's
Mr. Malhotra's mother.
But
Yes.
I am for the petitioner. But I really, would only beseech your lordship if
what
the
can be
talk
done?
was.
This
I
is the-
understand, I completely understand,
It's up to you. If you oppose, then I have to take it up. That's up to you.
I'll tell you,
For the
lordship,
private
this is
respondent.
very innocuous, prayer which have been led by Mr. Mitro, Mr. Shurujit Mitro, and Mr. Shamul.
Sir
Thakur.
Mondal, who is appearing, who is assisting Mr. Malhotra?
He's under treatment, but he's Arjuna.
Who?
Devasis something like.
He's also not available. Then what can be done? They are opposing Mr. Mondal.
I have an instruction, total
You have instructions. Can you appear? Why?
I have an instruction in this matter.
You have instructions. You can appear also because they are opposing.
Written instructions to appear or written instruction?
Make it not good.
Yes, what is this matter?
But I'll tell you, Lordship, Mulad, I'll tell you, Lordship, Mulad, this is Mulad, with regard to demarcation of a land,
No.
which is Mulad, the largest Mulad township, Mulad, which is Mulad, the largest township in Newtown. Mulad, this is Mulad, very innocuous, Mulad, really for demarcation of private land, Mulad, where? Mulad, there is Mulad, two notifications, two circulars which are prevailing right now, which says.
There is the provision under the statute
Mulad,
to demarcate a private property.
yes, Mulad, your Lordship had Mulad made this Mulad query.
Yes.
I'll now, Mulad, to clarify one aspect of this before my learned friend again says the same thing. Mulad,
I am the private respondent.
The private respondents had filed a suit. They themselves have admitted that the two properties are different, completely different properties. So I have nothing to do with their property. So far as their property is concerned, they can enjoy their property, do whatever they want with it. I want only a demarcation of my land. So they have nothing
What
to
is
say.
the suit for? It's their suit.
Their suit saying for injunction, damages against me, saying that you please do not disturb my property. I said, very well, you please stay with your injunction. I am not disturbing the property.
This is a dispute with regard to demarcation of a property.
Partition.
It's a civil suit.
Partition.
So it's best left to be decided by the civil court.
But first there has to be there's an undivided dog.
Let me complete
They
my
suppress
submission.
they
Let me
suppress
complete my
the plain.
submissions.
They
Thereafter,
don't.
Mulad, my learned
Right.
friend, my learned senior friend can Mulad, make his submissions. It's
Right.
very easy to say, Mulad, civil dispute. These are the few things, catchwords which we come forward when we come
Also,
in.
Mulad, innocuous.
Civil,
Also
civil
is innocuous.
Suit, civil suit. Then thereafter, Mulad,
Catchy words for so far as the court is also concerned.
I understand, Mulad. I completely bowed out.
Yes. Yes,
Mulad,
yes. File ta kothay?
if your Lordship Mulad kindly takes, please, demarcation. If your Lordship kindly takes, Mulad, there are two Mulad statutes which are prevailing, Mulad. One, Mulad, is the Bengal Survey Act, Mulad, which is Mulad prevailing. And Mulad, there are two circulars which I have Mulad included in my writ petition, which was shown to your Lordship on the last occasion. Mulad, these are Mulad the prevailing one, Mulad, a delegated legislation, and one, Mulad, an act, which Mulad empowers Mulad that in cases of Mulad breach of peace, there can be government armies deployed by an order passed by a competent court so that a private land can also be demarcated. There is also, Mulad, a government portal. Now, Mulad, these representations that we have made, it is a very, Mulad, really, Mulad, an innocuous prayer. This has nothing to do with, Mulad, any kind of, Mulad, civil dispute or, Mulad, any kind of other disputes between, Mulad, private respondents and, Mulad, the petitioner. This is only, Mulad, the plaint and, Mulad, I have, it's not annexed, we have craved leave to the, Mulad, plaint.
You can give me a copy of the.
Surely, Mulad.
Yes.
My learned friend, since he has copies, he'll also show your Lordship injunction filed, injunction order in my favor, vacating application dismissed.
So show everything. And the
want to only
see the cost.
Yes. And the scope of the suit.
Yes, kindly. Not with your Lordship's kindly.
Yes, yes. If Mr. Mitro permits you to.
No, of course. Of course. If your Lordship, madam.
Yes. Yes, Mr. Mitro.
আবার
মহারাজের বিটক
হ্যাঁ
মা মারা গেছে ইউ টেক টাইম
আচ্ছা
Mr. Mitro, you have an extra copy of this. Can I mark this?
Yes, yes. তোদের প্লেন এটা একই তুই তো দিবি
Yes.
Now,
No,
Mr.
but-
Mitra,
Yes.
you are the dependent in that suit.
Yes.
Now, the suit is for declaration of the Mr. Takka's client's title and pro forma dependent who may be supporting his client, and for permanent injunction from entering into the suit property and for
Yes.
disposition.
Very well.
So there is a dispute. It appears with regard to the
Now kindly come to the schedule.
yes.
This is where, my lord, the
RS and LR dag number 1077.
there is no dispute. On the north, RS dag number 1076.
You are the owner of which property?
On the south, my lord, rest land of vendor.
Vendor of the plaintiffs.
Yes.
You are the vendor.
No, I am again, my lord, the purchaser from the vendor.
So, demarcated portion.
My lord, if your
There's a
lordship,
sketch map in both
no,
the-
no,
So, how it has been said? Schedule of the deeds.
that is exactly
So,
why.
Mr. Mitso, that's best
No, but
left to be.
Kindly, who will do this? My lord? Somebody has to do it. Now, my lord, today, because of his 5 cutters of land, the claim over 5 cutters of land, my entire project is being stalled, which, my lord, runs into several entire project. Several.
The owner of 5 kathas.
Yes, only 5 cutters. Now, kindly look into, my lord, this map which I have prepared. Now, kindly tell. একটা copy দাও ওদেরকে।
Mr. Mitso, can you show the deeds of both the parties? Your
the
deed
parties.
and their deed. Mr. Thakkar, you can give your deed.
I don't have it here, my lord. I'm carrying that.
We'll bring it.
We'll bring it if it's.
And Mr. Mitso, are you having your deed?
He has
Who
his.
is the prior purchaser? Because admittedly, your vendor is common.
Apparently, yes.
So the vendor has purchased, vendor has transferred portions of a particular plot in favor of 2 parties.
Yes.
So the deed must show the demarcation.
Yes.
There may be 2 ways of transferring this, such and such share out of such and such, or demarcation. So whose purchase was earlier, your purchase or their purchase?
With 4 boundaries.
No, my lord.
Whose purchase was prior?
My lord, his deed is there in the writ.
Whose deed?
My learned
Mr.
friend.
Mitso's deed.
Yes.
No, who is the earlier purchaser? I think Mr. Mitso is the subsequent purchaser.
May
Because
maybe come back. With all the deeds
please,
and the chain deeds. That is required.
I'm not deciding the suit, Mr. Gaur.
My lord, we are only.
Deciding the
Yes.
suit. It's
My
not the
lord,
suit.
kindly look into the map which I have given, my lord.
Yes.
Now, my lord, kindly look into এই ওদেরকে কপি দিয়েছো? আমার তো খুঁজে পাচ্ছি না।
1077 is the disputed plot.
Yes. My lord, it's an undivided dark.
Now, kindly look into my
That
lord.
is all I want to say.
May I? Not may I? Kindly look into the map along with the schedule of, my lord, their plate.
Yes.
Now, kindly see on the north land of RS Zag number 1076
Which is not in this.
at the top on the plan.
You have not indicated north.
In.
Where? Oh, north. Oh, here you have indicated. All right.
Yes.
North.
1076.
1077 northern side is.
No.
1076. Yes.
Yes.
To the north of 1077 is 1076.
Yes.
Yes.
Yes. Now, kindly come to, my lord, the east.
East is RS 1078.
RS 1078, this large chunk of land.
Who is the owner?
I'm not on that.
All right. Yes.
So his 2 sides are given,
Yes.
about which there is no dispute, no claim. 1076
1077, part of 1077 is butted and bounded on the north by 1076, which he says, and on the east by 1078. Now, my lord, I say that his land, my lord, is a square land for his benefit, which is in blue.
So according to you, his land is blue.
Yes. It can be rectangular, my lord. If they want to make it rectangular, let them make it. They have.
You are the owner of which portion?
I'm the rest of it.
Of 1077?
Yes.
Mr. Thakkar, why are you not resolving this dispute?
My lord, you can
My lord, I'll
easily-
tell your lordship. I'll tell your lordship
You are
one
having
thing.
5
My lord-
katas.
I'll
My
tell
lord,
you.
I can.
This one way.
No. I'll tell your lordship.
My lord, this is not my map. This is a map attached to his vacating application, not to my plane. He has conveniently put my plot somewhere. This is not my map attached to my plane.
I have given the boundaries.
His own boundaries.
No.
My lord,
Where
kindly.
is your deed? Where is your deed?
My deed is not here presently. My lord, my schedule, kindly see my schedule. This is
Mr.
an
Mitchell,
undivided
you
dark.
have your deed.
My lord,
My
kindly.
deed is
Your
there.
deed. Where is
Yes.
your deed?
Yes.
Where is your deed?
His deed is at
Details
62.
are given. I have the copies, my lord.
Deed is at 62.
Copies you have purchased by various deeds.
Yes. 4 deeds.
4 deeds.
4 petitioners.
Rest of the balance portion.
107.
So the demarcation is different or same in all the deeds? Butted and bounded?
There's no demarcation. Cannot be, my lord. It has to be done by a civil suit or by a registered instrument. There has to be a decree of partition. Then comes demarcation, with my little understanding.
Mr. Thakkar, there are 2 things to it. A common vendor, by demarcation, transfers the suit for partition, subject to correction by you, is not.
No, my lord. The common there, he has to.
Cannot be maintainable.
Not common
because
vendors.
Once owner of a property transfers a portion of a property
Yes.
by way of demarcation,
Yes.
then unity of title and possession,
Correct.
which is the main ingredient for a partition suit,
My
is
lord-
destroyed by that transfer.
My lord, grateful.
Now, if it is undivided share transfer, it's another thing. If it is well demarcated portion, cannot be, there is a decision to that effect.
No, the undivided shares transfer the vendors.
May not be
My lord,
maintainable.
the vendors are separate, my lord. Vendors are separate. His vendors are also separate. With
If that is separate, then the question of partition does not arise.
no. Among
The question
the
of partition does not arise.
no, the vendors are the
Vendors are different, though they were having separate portions.
undemarcated. They also sold undemarcated. All vendors in one dag, undemarcated dag. Everybody bought undemarcated, unpartitioned. So that is why everybody is.
It is not also for partition.
My suit is not for partition. My suit is not for
It is not-
partition.
Then the suit is barred.
No.
So if there is a joint possession and there is a difficulty with regard to possession without maintaining the pair for partition, the suit
Well, the
barred.
suit is pending, Malad. If it's pending in appeal, it's pending in appeal. We will take whatever steps have to be taken there. But in this court, Malad, perhaps the greatest and similar orders, similar proceedings have been filed in this court,
Mr. Mitso,
where your lordships have turned down this order as a civil dispute. There is a precedent.
to go
There-
before the civil court.
I will
And
deal.
Mr. Thakkar, which court?
Of our court, Malad, there are several decisions similar.
This is pending before which court?
Barashat.
Local survey past commissioner is available. Have you taken instructions with regard to that?
I am not aware, Malad, because we are not contesting.
Subject to correction, survey past commissioners are not available.
They have not made any application there.
According to you, this can be resolved only by local investigation by a survey past commissioner?
By in the suit court.
In the suit court, wherever it is.
Yes.
It has to be by a survey past advocate commissioner. Most of the courts, there are no survey past advocate commissioners now.
Well,
This is the real fact. And these amins are being appointed
in
to
ex
undertake the work of this
in execution, Malad, at the execution.
No.
In the suit also.
In the suit also.
Everything, even in a partition suit. These commissioners are not available, I'm telling you. You can take instructions from your counterpart there.
There, yes. We are not aware.
Most of the courts.
My lord, I will tell
This
you.
is the real problem.
I think, Malad,
The problem, I will tell you, lordship,
we
I
cannot
always say
short circuit the
that, my
procedure.
lord, today,
The attempt to short circuit, nothing.
no, today, my
There's a
lord, we have
compensation
in
over-
this state, my lord, it's not a political statement. Kindly don't take it as a political statement. Today, we have 2 industries in West Bengal. One is, my lord, the development industry, and the other one is arm twisting industry. This proceeding is, my lord, the result of the second one. Now, my lord, kindly see, today, my learned friend says that civil suit. Now, civil suit, how can, my lord, the civil court, my lord, demarcate the property, my lord, if I may ask myself the
Can be
question?
done, Mr. So civil court cannot decide the demarcation.
He will say, my lord, this is my boundary. I will say, no, this is his boundary.
So that is the dispute which cannot be decided in a writ
That is
petition.
why,
Mr.
that is why, my lord, the amins, my lord, have been authorized.
You can approach the suit court for
That
making
is-
a demarcation.
That
That
is
can be done.
That is why, my lord, the amins have been authorized to do that.
Yes, so you can.
My lord, in fact,
What prevents you from applying in the suit court? Because all things, Mr. Mitsu, is very difficult here. Only it's not a question of making a demarcation, because one party will be aggrieved by that. Then objections to this report and other things, those will come. Because if it is, this has to be under the provisions of Order 26 Rule 9. If that is
Yes.
so, the report has to come. Automatically, it will form part of the record. But all persons have a right to cross-examine the commissioner. So all these things are to be done. It cannot be done here. So merely only a piece of evidence that will be brought by the writ court. Then again, how this demarcation or a report.
May I, in that event, kindly take it up on some other
Because
time, my lord, I will consider
if I allow your prayer,
Yes.
if that is done,
Yes.
the question of Order 26 Rule 10, it automatically forms part of the, you are well aware of those provisions, it automatically forms part of the record, but a person has a right to cross-examine the commissioner. So that person has to be cross-examined, everything. Now, whether the question will come, if the writ court appoints this,
my lord,
whether that will automatically
kindly,
form part.
kindly take it up on some other day, and my lord, kindly also, my lord, let them come up with the instruction of, my lord, which is their portion.
Their portion will be as per, they will be saying as per the deed.
Two borders are given. Now it has to be either this or square, whatever I have shown.
That, Mr. I'm not recording anything, that Mr. Thakkar may come up.
That,
because
my
the
lord,
main
resolves
issue is
that
whether
resolves everything. Now in the my lord, when my learned friend said that, my lord, I made a vacating application. There also, my lord, they say that my land and his land are completely different. It's not, my lord, we have common land. In Barashat court, they say in pleading that, my lord, this in the written objection, yes, pleading that, my lord, his land and my land are completely different. Admittedly. So, my lord, I only want a demarcation. I was trying to give him a square land, my lord, which is beneficial for, my lord, them.
So that is if both of you agree to that. So if Mr. Thakkar's client
Otherwise,
also
my lord,
agrees to that,
they
that's
can
a different thing
identify.
altogether.
They can identify, my lord, whether they, my lord, since two corners are given. If two corners were not, the two sides were not, my lord, indicated, my lord, it would have been difficult. Since two sides are given, today, my lord, the land has to be either square or rectangular. Nothing else. Five
Mr.
katas.
Thakkar, only one thing, without going into these issues, you have 5 katas of land in that plot. Can you not come to a solution? Because this will end everything.
Well, there's a lot of history.
Mr. Mitro is saying that he has indicated square. He can also give rectangle. He can also agree to a rectangular shape.
There's no map apropos this. This is his own plotting.
That is, you
Well,
can
there is
come up with a proposal. What is your plot?
Well, there is a lot of bitterness here, my lord. Police complaints, strong arm tactics. I don't want to go into that. That is why that is why we had to file the civil suit. I am
entering into that.
So, my lord, when your lordship says this, your lordship must also know the background. I am a 5 kata holder against a giant who's holding 500 kata. So, where is the strong arm coming from? I don't know. I'll leave it at that. I don't know. I can give it to that.
It's not it's a matter of argument, Mr. Mitro, while arguing is using some expressions.
Yes.
Let us forget about that.
Yes,
So
ma'am.
you are you are having title in respect of 5 katas in a particular dark.
Yes, ma'am.
So maybe the dispute arose with regard to the identification. You may say not this part, another part. Mr. Mitro may say, "No, as per the deed, you do not have this part, that part." So if both of you can come to a solution, this
No,
part
let him-
agreed upon, that can end all.
Let his clients
Since
approach
two
my
sides are
clients.
given,
Let
since
his
two
clients
sides are
approach my
given.
clients. In the meantime, I'll file my affidavit. If the clients can resolve it, well and good. Otherwise, I'll take the point of maintainability. Your lordship. Very well. Without affidavits, I will issue. I will argue
Sides are
maintainability.
given. Had it,
There is
had
no
it-
side given.
two sides were not mentioned, my lord, I would not have made this submission. Then in that event, they could have said anywhere in this.
All right, Mr. Mitro, please come ready with the regard to the point of that maintainability, because even if your prayer is accepted, what will happen? Because after all, this demarcation and other things, objections and other things, these are to be decided, has to be before the suit court.
And the primary question frame, your lordship, where is the right in law to demand? That also, my lord, which I will also argue, my lord.
Yes, yes, that is.
Government notification does not create a right, number one. And number two, my lord, has to have a foundation in the law, the parent law. And secondly, my lord, similar praise
Where is
make
that statute survey act? Do you have a copy of that? Because Land Reforms Act, I think, subject to correction, do not have.
I
any
could
problem
not find
with
it.
that.
Land
Survey Act. Yes, which
40, my lord.
does not apply to
section
private.
40.
Safe नहीं करके रखते हैं। अरे सर्वे बंगाल सर्वे एक्ट सेव किया था तो
ঘন্টা পড়েছিল যেহেতু ঘামবার করে দিচ্ছে কেটি তোমার ঘামবার করে দিলি রে
জজ সাহেব বলছেন চলে যান এসি পাঙ্খা সব বন্ধ হয়ে গেছে
40 is a different thing altogether, Mr. Mitro.
No, the power comes from that. Collector has daily
survey.
Yes.
Survey is section 3.
Correct.
Yes.
Survey is section 3.
Yes.
Survey with regard to any district, part, plots, those surveys. That's completely, it does not say survey with regard to a dispute, boundary dispute between two private individuals.
It determines such
dispute, boundary dispute with regard to two plots. So let us suppose there are two plots. What will be the boundary of those two plots at the time of survey for the preparation of a map? That falls within section 40, not a private dispute with regard to a identification of a property.
May determine such boundary, my lord.
Because this collector's powers is survey, it's a different thing. This is a survey of the plots.
Yes.
It's for a different purpose.
Our court has held this, my lord. A coordinate bench of our court has held exactly what is falling from your lordship, if your lordship may kindly consider. Coordinate bench of our court has held this, my lord. Exactly what is falling from your lordship. Private dispute, the Bengal Survey Act demarcation does not apply, my lord. Section 14, my lord.
40 is, I think in one matter, I've also considered this act and have said, Parthapratim Roy, I think he appeared in this matter.
I'll ask
one
him.
of the matters.
I'll ask him. Kindly.
Sorry, my lord, we did not miss.
Considered this.
I'll consider that.
Section 40, no. I've not considered section 40 in that line, but cursory glance of that seems no. It's for a different purpose altogether.
Last part of section 40, my lord, I thought.
It's for the purpose of that, not for the purpose of a private dispute. Survey under this act.
Correct.
Then, my lord,
Survey
kindly
is
come to
section 3.
kindly come to 41.
41, yes.
The collector shall determine the boundary according to actual position.
Yes.
And cause it to be secured by boundary marks. This has to be, my lord, for the individuals or my lord. Then,
42.
my lord, 42.
All has to be read. Collector
Yes.
to take possession of the land in dispute. Now, while taking
Public
possession,
land.
if
Yes.
there is a dispute, Mr.
He
Mitro,
unable
please-
to discover which party was in possession of the disputed land
yes,
when
yes.
he instituted the
So
inquiry.
if a portion is being acquired, possession is
Yes.
sought to be taken.
It's
There
public
is a
purpose.
dispute. Which,
And-
so
and-
for that purpose,
This read with the notifications, my lord. This read with the notification. And my lord, this court, my lord, I will show your lordship, my lord, there is a judgment of this honorable court. Again, a coordinate bench.
no, coordinate bench is binding.
Which says that yes, it can be done.
Yes, I'm aware of that because that was placed before me while I was taking up that matter. Thereafter, when I asked the learned advocate to back that and said, no, I'm not relying upon that. I think one decision was placed.
Subject to correction, there was a
When I
partition
asked
decree
him
in
that,
that
are you relying
matter.
upon this? He said, no, 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 give me back. So he made
I'll
submission.
again check. I will again
There
check.
was a
I don't.
Can
partition.
rely upon that decision. I will have to, then I, because coordinate bench decision after all is binding, and Mr. Thakkar is also
Yes.
relying upon another coordinate bench judgment, taking a different view.
Government has subsequently
But
clarified, my
in
lord.
this judgment, it has been said that there is no provision now, but section 40, 41, which you are now relying upon, that has not been
That has
considered.
not been, and my lord, the
That has not been considered.
notifications have not been taken.
The notifications which you relied upon on the last occasion,
Yes.
It was issued under which provision, which statute?
Page, my lord, kindly come to page 79. Kindly come to page 8. 79 was done away with, and then 80, after careful consideration of the aspects relevant to the issue, it has since been decided that the government tamine shall not be deployed for measurement of any land other than government land, except the cases where there is specific order of any competent court for measurement on deployment of government tamine, and or where there is sufficient ground of apprehension that there may be breach of peace of the locality for demarcation dispute. And then, my lord, kindly come to 78.
Page 78.
Yes, the next one.
Yes.
First paragraph. There are heavy pressure for demarcation of private land from different districts, even by court order. Since no decision of the Land and Land Reforms Department has been taken on the above noted subject, the following proposal, keeping in view Allied Department's guideline of that page 79, is made in partial modification of our earlier proposal, and rates are communicated to the District Land and Land Reforms Officer. In anticipation of his approval, the Amin will be deployed for measurement of private land only on the order of competent court, etc. The rates.
Competent courts, that is executive or criminal court.
That is what was falling from your lordship.
Is 144 CRPC.
Yes, exactly.
And all
That is
so. Only for that part.
That is again, my lord, the subject matter of this rate. I have said that I have lodged complaint, and my lord, nothing is being done. Part of the writ is also police inaction.
Then I do not have determination.
No, both. This point, they took this point before the other bench.
And I'm not taking point of jurisdiction. I'm not taking point of roster or jurisdiction.
If you do not take that point, because consent cannot confer jurisdiction. First. Second is, I'm a part of a full bench.
Yes.
Where it was said if it is without
nullity.
There a point was taken that this determination should not be looked into as other jurisdictional issues, because the Chief Justice is the master of rosters. In that it has been held no. If there is lack of determination,
nullity.
Order is nullity.
I'll tell your lordship now. This writ was moved before the, my lord, residuary bench. There, my lord, point was taken that, my lord, the residuary bench does not have the jurisdiction. Then, my lord, I applied for, my lord, my client had applied for, my lord, assignment. They objected to that. In writing, I have a copy of that letter. They objected to that, and the department has sent it before your lordship.
No assignment. Your lordship has jurisdiction, my lord. I don't think it's a case of your lordship not having jurisdiction, because it's a land matter.
No, it has been assigned, or before the
they
where is the
objected
order of assignment?
They objected to it. I have copies of those letters.
Assignment
No. The department has sent it before you.
As group 1.
As group 1, correct. There's no need of assignment. It was filed in the wrong group.
Very well.
That is what we said.
Now we are
There's no
before the
question
right
of
bench.
assignment. There's no question of assignment. It has to go before in the right group. Our objection was on assignment when there is a bench available. There is a bench available, it has to come before your lordships. It can't be assigned to any other bench. It's a group one matter. That is the assignment. There's no need. And my Lord Justice Rao's order shows that it should be filed before the appropriate.
All right, Mr. Mitso, because this maintainability, this is
Troubling your lordship. Yes.
because
Very well. My lord,
even if I accept your prayer, the question will be what will be the effect of that?
very well.
Because
Hey,
report,
court will
other
become a
things, because
demarcation authority.
Very well, my lord. Kindly keep it, my lord. Eh? Whenever it is convenient, some time would be required.
how much time you tell me?
No,
When? No, some time for hearing or some time. you
no,
to
no.
take
That, my lord.
next week, any day, which day?
Monday, my lord. If it is convenient.
Please, my lord. Monday, acha to.
তারিখ আছে?
Yes, please, my lord.
Yes, Mr. Mondal, 20th.
As for the orders, my lord.
For orders.
For our benefit. This is for our benefit.
So perhaps it will be reached because if it is also in the same. Heard both of you please bring your respective deeds. Mr. Thakkar, also bring your respective deeds. Yes, call the next matter.
Grateful, my lord, deeply.
Call the next matter. Yes, yes.
On behalf of Divyajyoti Basu, we are praying not today for state.
Yes.